Yeah, let me- Go ahead and talk about a couple of things before we get started, and that includes the presence of Mr. Keetley. Good morning and welcome. As well as all the defense attorneys, and on the other side, all the assistant state attorneys are present. So I've just been instructed that all 15 of the jurors that we selected, 12 jurors and 3 alternates, are in fact present and back in the jury room. I believe you all received a chart of how they're going to be seated in the jury box.
Yes, sir, we have.
And State, did you get your copy chart?
Yes. We did.
Okay, excellent. So I also received, Ms. Johnson emailed the preliminary instructions over the weekend or Friday night, which I have in front of me now. I always start with 2.1. If you look at, there is 2 other instructions included. One is the qualification instruction. If you look at the language of that, that's given to them before they even or it's intended to be given to them before they're even brought to the courtroom for the selection process. And then if you look at 1.1 introduction, all of that language is in 2.1. So I do not normally read 1.1. Have the defense looked at the proposed instructions?
As far as what you, the whole, not necessarily, because I know we'll have a charge conference, but as far as the
Preliminary, just the intros that I'm going to give this morning.
Yes, sir.
So is there any objection to me starting with 2.1? And have you looked at 2.1? It's 99.9% standard. There's just some fill-in the blank, which it appears that they've done. So have you taken a look at that?
Yes, sir.
Any objection to it?
I have not seen anything there, typo or anything like that, so I think we're good. If there's a typo, I don't know if they got one, but
the only other one that I will give this morning before we proceed to openings is 2.1A, note-taking by jurors, and they have already been provided on their seats a notepad with pen. So I'm going to give 2.1 and 2.1A, and then we're going to do the opening statements. Now, I understand that opening statements in this case may be a little bit lengthy, and I have no problem with that. I'm not rushing anyone, but it may be appropriate for us to go ahead and take a break. Let me just start with the State. State, approximately, who's doing the opening?
Ms. Johnson. I am, Your Honor.
And approximately how long, Ms. Johnson, do you expect your opening to take?
Judge, between 30 and 45 minutes, probably closer to 30.
Okay, all right, 30 minutes. And who for the defense?
it will be me, sir.
All right, and how long, Mr. Grant?
Nobody say
Approximately.
yes, I hear you. Dangerous question. I would say between 60 and 90 minutes.
60 and 90. All right, and that's what I had heard.
Yes, sir.
What I'm going to do, though, is I don't know if the state only takes 30 or 45 minutes. That's too short to take a break in between. So I'm thinking that if you're going to be an hour and a half, that when you add it to that is too long for them. So I'm going to have to take a break somewhere in the middle of your opening. Or if you have other suggestions.
I would make a suggestion because I think your preliminary instructions are going to take 10 minutes or so. And knowing that usually...
If you want me to read slow.
Yeah.
That's fine.
You pronunciate your words, right? What I would tell you is usually my experience is when a lawyer says between 30 and 45, or in my case 60 to 90, it's usually more towards the high point. But
I have that same experience up here.
Right, and my suggestion would be, even if it's just a short break,
Well,
be able to take it because we're going to want to move our board.
No, okay, not a problem. If you need to move stuff in between, that yes, that adds to the equation of my making my final determination. But what I was going to say is that there are no short breaks with 15 of them.
Sure.
There is one restroom back there, and assuming they all want to take advantage of that break, I usually cross my fingers and hope that we can do it in 20, and I've never had that happen with 15 of them. So breaks are going to be well over 20 minutes. But I don't have a problem breaking. Is there any objection from the state? It's a clean break after the state's open. I do have to do instructions after your opening, however long it takes. We'll take a break. They can set up their stuff and then come back and do that. And if you do take 90 minutes, we'll take another break before the state calls their first witness.
And Judge, just so the court knows, for the vast majority of the witnesses, we'll be bringing our board out in order to use that board even during cross-examination.
How about how long does it take you to set up?
It just takes us 5-10 minutes, only because of the fact that we're wanting to make sure that everything is functioning, everything is in, and that we know where it's at before that presentation. It doesn't take that long. We're pretty comfortable with it, but I just wanted to let the court know.
No, I appreciate it. We'll have to see how that plays out. I mean, I don't intend to take a break every time we cut to cross-examination, so you're going to have to do it in front of the jury as quick as you can before you start your cross.
Yes, Your Honor.
But we'll see how that plays out.
Judge, we haven't been presented with anything that would be utilized, any evidence that's going to be utilized during opening. So we would ask that if any media or any evidence is going to be utilized, that we see that beforehand.
Yeah, do you have anything you're going to use in opening? If so, you need to show it to them.
I do, and I'll talk with them further on that quick break, but I anticipate showing a picture of the house, or the front. I anticipate the text message being shown, and I anticipate the standard operating procedure. We may also show the photo pack of Mr. Guevara.
All right. Well, and as I said, that break is probably going to be on the low side 20 minutes and hopefully no more than 30 minutes. So during that break, make sure that all of that is available for the state to take a look at. Is that all right with you, Ms. Johnson?
Yes, Judge, that's fine. Something else came about before Your Honor came out. Defense counsel had approached us and had wanted to make sure that we weren't going to be getting into any character evidence regarding the defendant, and I certainly would not be doing that in opening. And I asked the same of them regarding state's witnesses. I gave them some examples of some of the witnesses, that there were numerous and lengthy motions in limine regarding several witnesses in this state's witnesses in this case. I was informed that because there was no written order done regarding those, that they were not aware of what I was talking about. And so my concern is that I tried to show Mr. Grant an example of Miss Stacy Rogan, character evidence that had been ruled upon and ordered by the court. Specifically, I believe it was on March 16th, March 16th of 2017, where numerous motions in limine were heard by the court and ruled. So my concern is that defense counsel says there was no written order, and so he was not aware of them. And so I want to make clear that any motions in limine that were ruled upon by Your Honor and that have not been revisited by Your Honor, that all parties are to be informed and well aware of those orders and rules and should not go into any of that evidence.
Well, that should go without saying. Does the defense intend to violate any previous orders, either written or unwritten?
No, sir, and it's not worth going into the full conversation. We were getting these things. Nothing specific. We don't intend to go into anything inadmissible as far as character evidence. We've consulted with Ms. Kolev, who will be doing the witness, Ms. Rogan, and she's well aware of what we can and cannot go into based on the court's rulings. So,
Well, my position at this point is proceed with caution. Certainly if there's a objection and an argument that you violated a motion in limine, it may result in a mistrial and having to do all of this over a third time. I hope you recognize that and don't intend to put us in that situation.
absolutely, and I would hope the same for the others as well. So we're well aware.
All right, Ms. Johnson, is there anything else you'd like me to discuss with them related to that?
Nothing further, Judge.
All right.
And I'll just make sure from Ms. Johnson's comments, it sounds like she doesn't have any intent to show any media or anything in her opening statement.
No, Your Honor.
Okay,
Okay.
we're good.
All right. Then I think we're ready to get started with the opening statements. So let's bring the jury in. The cameras, I usually just very briefly say not to be concerned or about the cameras, and that shouldn't affect them in any way, that the cameras will not show their likeness at any time. Any objection to that?
No, Your Honor.
No objection, Judge.
Thank you.
Judge, you're okay with us having a drink nearby if
Yeah.
necessary?
What kind of a drink?
It's a Coke.
Non-alcoholic?
It's a Diet Coke for me.
Yes, yes, absolutely.
Okay.
Jury's coming in. Before you do, very quickly, formally, we'd like to invoke the rule of sequestration.
All right, if there's any witnesses in the courtroom, the defense has invoked the rule of sequestration, which means that you are not to be present in the courtroom while other testimony is taking place. So I will ask you to please step outside. I'll also ask the state to inform all of their witnesses regarding the invocation and the defense to inform all of their witnesses regarding the invocation. The bailiffs who are sitting at the back when someone comes in will normally ask them if they're a witness, and if they indicate that they are, we'll let them know. But as long as you let all your witnesses know, that shouldn't be an issue.
Your Honor, not only in here, but also on court TV.
Well, you know what? Absolutely. Instruct the witnesses, because we've had that come up before where we're being live streamed or broadcast in any other means. So please make sure that you let your witnesses know that that means they can't watch any reports of the proceedings or live stream of the proceedings, both sides.
Yes, Judge.
Thank you. Present and seated, everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome back. Happy Monday. And thank you again for all of your hard work last week and your patience with us during the selection process that took 4 days. I hope you enjoyed the Friday that I gave you off because you had worked so hard with us all week. And thank you for coming back this morning. I hope you had a nice weekend. We are going to get started. There's a couple of things that I need to do with you before we begin. One of them is read you some preliminary instructions. I do apologize for reading to you, but every word of them is important. They are written by the Florida Supreme Court, and I don't want to inadvertently or mistakenly leave something out. The other thing that I want to mention to you before I begin with the instruction is that you may notice that there are cameras throughout the courtroom. Those cameras may be related to reports outside the courtroom, media, and things like that I have also warned you through every stage of this and every night and every break to avoid any reports of the case. You are now in a new courtroom. This is my courtroom. It's a little smaller than the courtroom across the hall, but you do recognize, as I said, that there are cameras in it. So a couple of things with that. First, I want to instruct you not to be concerned about those cameras in any way whatsoever. They should have no effect on you. They also know, whoever is behind those cameras, not to show your likeness in any way. They will not do that. So the cameras will not show the jury at any time. The other thing is, that means that there will probably be reports about this case outside of the courtroom through the course of the proceedings. So it is very, very important that you avoid any of those reports. Social media, print media, television media, social media, anything. I think I said social media to begin with. But any reports, as you know, and I apologize for being redundant about this, but I've done this a few times, and unfortunately it happens. Somebody might be inadvertently exposed to something, and then we have to address it. I'll ask you every time, as I'm about to ask you now, since you had Friday, Saturday, and Sunday, whether anybody was exposed to anything. But I just wanted to let you know that we're going to continue with that same rule that you cannot discuss the case with each other, you cannot discuss the case with anyone else, and you must avoid all reports about this case outside of the courtroom. So I want to ask now, before I read you the instructions, by show of hands, was anyone exposed to anything about this case between the time you left the courtroom number 1 Thursday night, I think it was, when we finished and got you out of here, after 6:30. So Thursday night, and now that you've walked back into now this courtroom where we're going to try the case, anyone by show of hands exposed to anything about this case? Let the record reflect no hands. Anybody discuss this case with anyone else amongst themselves or with anyone other than the jury? Let the record reflect there are no hands. Again, thank you all very much for your attention to those rules and your patience with us. I am now going to read to you the preliminary instructions. Part of those instructions tell you how the trial will proceed, so that I don't have to keep yelling. Not that I was yelling at you, but I'm going to turn on my microphone while I read. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Michael Keetley. This is a criminal case. Michael Keetley is charged with murder in the first degree, 2 counts, and attempted murder in the first degree, 4 counts. The definitions of murder in the first degree and attempted murder in the first degree will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Michael Keetley in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instruction on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussion of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family member make comments to you or ask you questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer the question. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences do occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. That is all of the written instructions. What I want to do now, ladies and gentlemen, before we begin with the opening statements, is to ask you to take your pens out and take them for a test drive to make sure that they are in working order. We recycle pens. They will eventually run out of ink. I want to make sure they're working when we get started. I also want to let you know to please not be shy. If at any time during the course of the proceedings your pen appears to stop working, please raise your hand, get my attention, or the bailiff to your right's attention. We have plenty of pens stockpiled in the cabinet, and we will be happy to replace any pens when necessary. Additionally, if for any reason you run out of paper in your notepad, we'll give you an additional notepad when required. I also want to just comment on the instruction that said you will never take your notepads or your notes from the courtroom. You will take them back with you when you begin to deliberate. So you will have those notes when you were at the end of the trial when you were deliberating. So that's all that I have. I'm now going to turn to the state and ask if they are ready to give an opening statement. State?
Yes, Your Honor.
Ms. Johnson, you may proceed.
May it please the court, co-counsels, defense counsels, Mr. Keetley. Good morning, ladies and gentlemen. Obsessing about revenge, that's what this case is about. Obsession with getting revenge is what was on the defendant's mind the early morning hours of November 25th of 2010. The only thing on his mind those early morning hours of that Thanksgiving morning in 2010, when he shot and killed two innocent victims, two brothers, Juan and Sergio Guitron, and tried to kill 4 other victims who fortunately survived the horrifying events of those early morning hours. Those 4 victims being Richard Cantu, Ramon Galan, Gonzalo Guevara, and Mr. Daniel Beltran. In order for you to understand how we got to the obsession with revenge on November 25th of 2010, we need to go back to January of 2010. Almost to the day 11 months prior to the horrifying incidents of that Thanksgiving morning, where in January of 2010, when the defendant, Michael Keetley, was working as an ice cream truck driver in the Ruskin area, and he was robbed by a black female and 2 black males. The black female had approached his ice cream truck and had attempted to make a purchase when 2 black males came up, robbed him of $12, and shot him. Mr. Keetley sustained injuries, and he contacted law enforcement, where the Hillsborough County Sheriff's Office began their investigation as to that robbery of Mr. Keetley. They obtained a description for Mr. Keetley, that being of a black female and 2 black masked males, and a description of the suspect's vehicle. Law enforcement, as they do in all of these kinds of cases, began their investigation, working on leads that they were able to have, working off of the information that Mr. Keetley provided to them. And unfortunately, they were not able to make any arrests in that robbery investigation. They were not able to identify any suspects. And Mr. Keetley was upset about that. He was upset that he had been injured and that no one was going to pay for that. He was upset that law enforcement was not able to complete and close out that investigation with an arrest. So he decided he was going to do his own investigation. He was going to go out and speak to witnesses. He was going to try to obtain evidence. And as this case will unfold over these next several weeks, you will learn from numerous witnesses about what he did in his investigation. He spoke to people in the neighborhood. He conducted research, website research on his laptop. He obtained firearms. And as his investigation unfolded, word on the street was that Hispanic individuals, Hispanic males, were in fact responsible for the robbery. Not the individuals, not of the individuals of the race that he ultimately had identified or had provided to law enforcement. And that he had uncovered these Hispanic males were the ones who ultimately had caused him harm and had robbed him. And as he is uncovering this information, as the word on the street provided him, that a person by the name, a Hispanic male by the name of Creeper, nicknamed Creeper, his name ultimately being learned was Omar Bayan, was in fact one of the individuals who had robbed him. And so when Mr. Keetley gets that information, you will learn as this case unfolds and viewing evidence and exhibits in this case that he researched and spoke to people about Creeper. He told his friends, his girlfriends, look for Creeper, look for a man with the nickname Creeper tattooed on his arm. This is what he is telling his friends and his girlfriends over this 11-month period. And as he's conducting his own investigation, he learns that this Creeper man lives at 507 Ocean Mist Court. And why is that important? Because this horrifying incident that occurred on November 25th of 2010 was at the address of 604 Ocean Mist Court, just down the street from the home of this creeper person. The defendant, you will hear from witnesses, enlisted his friends to help him in his investigation. Not only look for this creeper, but he had a female by the name of Norma Jean Towers, who he had drive through this area looking for creepers, driver's tag. The defendant covered his face up, wore a hat and covered his face up as he had her drive through the neighborhood looking for tags that he was going to be able to complete his investigation. He had offered a reward that he had signed, he had posted on his ice cream truck, offering a $5,000 reward to help him find this creeper individual. You'll have testimony from witnesses that he approached a 13-year-old girl and interrogated her to tears, trying to find out information about creeper. You'll hear that he hired his friend David Beckworth to be his muscle after the incident that had occurred in January where he was injured. And David Beckworth worked with him with the ice cream truck to help protect him and to help find this creeper. And David Beckworth had agreed to help his friend find creeper and take him down. The agreement was to dress up like cops, hunt them down, and kill them. But as this case unfolds, you will hear testimony from witnesses. For example, Ms. Logan, who's going to tell you that those early morning hours of November 25th of 2010, David Beckworth wasn't with Michael Keetley. He was with her at her family gathering, preparing for the Thanksgiving day, smoking a turkey. So although the plan was for David Beckworth and the defendant to gun down this creeper, Mr. Beckworth was not with Michael Keetley those early morning hours when this horrific incident took place on Thanksgiving morning. Law enforcement did continue to attempt to conduct their investigation. Mr. Keetley would take law enforcement the leads and the information that he had, but he was not able to give them any witness names that they could go and gather an ultimate witness to say, how do you know Creeper was in fact involved in this robbery? And it was also concerning to law enforcement that he had originally identified a black female and 2 black males. And now he was saying it was a Hispanic males, one with the nickname Creeper. And this obsession with revenge is festering and festering from January until November 25th of 2010. And you will see that from the evidence, from the laptop research forensic evidence. He looked up Bayan, who belongs to Omar Bayan, 11 times. He looked up law enforcement 22 times. He looked up Ocean Mist 92 times. He looked up Glock, as in the Glock firearm, 2,353 times. He looked up uniform 3,996 times. And as you learn the facts of this case, you will understand why Glock and uniform become important. He looks up Omar 11,602 times on his laptop. Let's talk about what happened those early morning hours of November 25th, 2010, approximately in the 2 hour in the morning time frame. That Wednesday night, the 24th, the day preceding Thanksgiving, into the early morning hours, the victims were friends. and they had decided to gather at 604 Ocean Mist Court because they didn't have to work the next day. So they were going to hang out, have some drinks, play cards on the front porch of Ocean Mist Court. And Juan and Sergio, Daniel Beltran, Gonzalo Guevara, Ramon Galone, Richard Cantu, Jose Rodriguez were all there hanging out that night. They were drinking beers, they were playing poker cards, and 3 of the victims did partake in drugs, in marijuana and cocaine. And you will hear that as they were sitting there on that front porch of 604 Ocean Mist Court, those early morning hours, they see a dark-colored minivan come down the street, which was a little odd because it was so early in the morning, 2 a.m. So they notice the vehicle, and then it comes back towards the home and pulls up at the end of the driveway of that home. And as they are looking at the vehicle, as they are sitting there on the porch, as they had been hanging out earlier, they see a white male individual exit that dark-colored minivan. And that individual is wearing a black t-shirt with a law enforcement name in white big block letters, either police or sheriff, across the shirt. And he has a gun in his hand. And so they are thinking, some of them that had the drugs that were still there, oh, there's law enforcement, they need to put the drugs away. So as this individual, this lone gunman, approaches, who they believe to be a law enforcement officer at the time, approaches the steps of this front porch. And they wonder what this law enforcement officer wants of them. Well, this individual, this white male dressed in a black shirt with white block lettering, dark green and black pants, camo style pants, demands, "Where's Creeper? Where is Creeper? Who is Creeper?" and has his firearm. These individuals, the victims on the porch, they know Creeper, they know Omar Bayan, but Omar Bayan that night is not there. He was not on the porch on November 25th of 2010. And as you'll recall, I told you his address, as the defendant had learned through his own investigation, was actually 507 Ocean Mist Court. But there were multiple Hispanic males out on that front porch that early morning. And as this gunman, who at that point they still think is a law enforcement officer, is demanding, "Where's Creeper?" The law enforcement officer demands they pull out their identification cards to see if they're telling the truth, which they do. He tells them to get down, which they do. They get down on their knees, they pull out their driver's license, and Creeper, Omar Bayan, is not there. That's when, one by one, execution style, the defendant shoots the victims. This lone gunman is there, and when the first victim is shot, that's when they realize this is not a law enforcement officer. None of them have guns on them. None of the victims were armed the early morning hours. And as you will hear testimony from the surviving victims in this case, you'll hear testimony as to what they remember. And you'll hear that one by one they heard the shots of their friends in the backs of their bodies as they were kneeling on that front porch. You will hear testimony from the medical examiners in this case, Dr. Mary Mainland, who conducted the autopsies of Sergio and Juan Guitron. And before Dr. Mainland responds to that scene, you will hear that ultimately when Sergio and Juan Guitron are shot and killed, and the other victims are there. 2 individuals are able to flee from that porch, ultimately, after the victims were shot. You have Jose Rodriguez, who was there, who was able to flee and was never injured. He is the one individual that would never sustain a gunshot wound those early morning hours. And you'll hear from Daniel Beltran. He was shot multiple times, but he was able to flee once he soon realized that this individual who he thought was a law enforcement officer approaching that porch was not, was anything but a law enforcement officer. You will hear that since they were unarmed, they were not able to defend themselves. You will hear from Daniel Beltran how he tried to get his friends' attention at the beer bottles that were just in front of them because he thought maybe they could use the beer bottles to defend themselves those early morning hours, as one by one his friends were being shot around him. The victims, the surviving victims in this case, will tell you there was one gunman and there was one gun. Ultimately, Sergio sustained one gunshot wound to his back. Juan Guitron sustained 2 gunshot wounds to his back. Each one of those taken individually were both fatal. Each one was fatal in and of itself. Richard Cantu was shot in the back of his head. And he, unfortunately or fortunately, however you look at it, has no memory of this incident. Gonzalo Guevara was shot 4 times, including in his back. Ramon Galan was shot on the right side of his body that traveled through his stomach and exited out the other side of his body. Daniel Beltran was shot 3 times in his hip, his chest, and had a graze to his face. And he was one that was able to escape. You will hear these victims testify about what they went through, what they observed, what they were thinking those early morning hours of November 25th of 2010. You will hear from them that they were rushed to the hospital. All of the victims were taken to hospitals or by ambulance or taken by air to the hospital. All but Sergio Guitron. He was left at the scene and pronounced deceased on that front porch of 604 Ocean Mist Court. Juan Guitron was later pronounced deceased at the hospital. And law enforcement began their investigation soon thereafter, soon after this incident occurred. They arrive on scene, they secure the scene. They learn what hospitals the victims were being transported to. They start documenting the scene, marking items of evidence that were left behind on that front porch and in the area surrounding that front porch, such as shell casings, wallets, driver's license that were left behind. Ultimately, they collect those items of evidence that were sent off for testing, and we'll talk about that in a little bit. Law enforcement conducts interviews of individuals that may have information about this case, and ultimately when the victims are able, the surviving victims, when they are able to provide a statement to law enforcement meets with them in the hospital. And they learn of a description provided by the victims. This white male one individual with the black t-shirt with the white law enforcement lettering and the dark camo pants with one gun. The description that law enforcement obtained from multiple victims in this case. The dark-colored minivan. And they learn of the identity that this individual had been asking for Creeper and had demanded to see their driver's license. Law enforcement learns Creeper's nickname is linked to Omar Bayan. They also interview other individuals, such as Stacy Rogan, who when she hears about this incident the day after, Friday, November 26th, hears that multiple Hispanic males had been shot at over on Ocean Mix Court, she reaches out to law enforcement. And she tells law enforcement that she used to date Michael Keetley. And he had told her if she sees a man, a Hispanic male with the name Creeper tattooed on his arm, for her to call him. Call Michael Keetley. Don't call law enforcement, call me, is what he told her. Law enforcement follows lead upon lead upon lead in this investigation. They speak to Mr. Guevara, who was still in the hospital, who had been sedated for several days after his injuries. And ultimately, Gonzalo Guevara makes an identification in a photo pack. You will hear testimony about that. You also hear testimony from a prior hearing where Jose Rodriguez, who was not injured, fortunately, that night, but he also makes the identification in that hearing of Michael Keetley being on that porch, being the lone gunman, early morning hours of November 25th of 2010. All of this investigation that law enforcement is conducting leads them to the defendant, Michael Keetley, where they interview him on November 27th, just a few days after Thanksgiving. They interview him and they ask him. They asked him if the word on the street is that Creeper is responsible for his robbery. What does he tell them? No. He's asked if he ever heard about a guy named Creeper. He responds, no. He's asked if he ever asked anyone else about the person named Creeper. He responds, no. You will hear testimony in this case, witness after witness that will sit in this chair and tell you all that Michael Keetley told them about Creeper. In that interview, Michael Keetley also admits to law enforcement that he owned a Glock 21 that shoots .45 caliber. Why is that important? The shell casings and the projectiles left behind at the scene of 604 Ocean Mist Court are .45 caliber that were left around the front porch and under the front porch, which is consistent with what the victims had said, is that they were kneeling down or down on the porch when they were shot. The following day, after the 27th of the interview of Michael Keetley, law enforcement responds to the Keetley property, the Keetley residence. It is a huge property where multiple homes are located on. So on the 28th, law enforcement is continuing with their investigation. They have searches of the home, the property. They obtain numerous firearms. Mr. Keetley was an avid gun owner as well as his family. They obtained numerous firearms during the search of that home. There are shooting areas on that home and that property where there are items that were ultimately collected. Most importantly, a .45 caliber projectile near a van that had been used as target practice. There was a burn pit where a .45 caliber shell casing had been located. Multiple guns were recovered on the 28th during law enforcement search, except one important one, the Glock 21 that shot .45 caliber. A laptop was recovered from the Keetley home, as well as a composition notebook that was sitting on the kitchen counter. A composition notebook that on the first page, when you open it up, has Omar Bayan 507 Ocean Mist written on it. Law enforcement collects that. Ultimately, testing is done on that composition notebook. Latent fingerprint is lifted from the inside cover of that notebook, as well as the page where Omar Bayan and his address is written down. That fingerprint is matched to none other than Michael Keetley. Let's talk about the evidence that was sent off for testing that was ultimately collected from the scene, the projectile found at that shooting target on the Keetley property, and the shell casing that was found in that burn pit on the Keetley property. In addition to other shell casings that were obtained by law enforcement during this investigation. And they obtained other shell casings in this investigation from an acquaintance of Michael Keetley, who is Mr. Wesley Smith. Mr. Wesley Smith is a machinist. He and his co-workers would frequently buy ice cream from the defendant following his injury. And one day, the defendant engaged in conversation with Mr. Smith. And the defendant had learned that Mr. Smith is a machinist, and Mr. Smith will tell you that typically being a machinist and people who are into firearms are typically asked, do you work on firearms? Do you make any kind of modifications to firearms? And so Mr. Smith, being an avid gun owner himself, him and Mr. Keetley had this common ground and spoke about firearms often. And ultimately, one time, Mr. Keetley even invited Mr. Smith and his wife, Miss Carmen Smith, over to his home, where they shot firearms together. Mr. Keetley fired his firearm, his Glock 45. Mr. Keetley allowed Mr. Smith to fire the Glock 21 that shot out .45 calibers. Ms. Smith was also there and observed all of this. And Mr. and Mrs. Smith picked up the shell casings after. They tend to recycle them. And also they were concerned about the livestock that were on the property, potentially getting into those. And so when Mr. Smith was interviewed in this investigation, he had told law enforcement that he and his wife, when they had previously been to the Keetley home a few weeks before the incident on November 25th of 2010, that he had shell casings from that shooting get together. And he provided them to law enforcement. He didn't know if they would be helpful. So ultimately, you will hear from Jennifer Clark, who is an analyst with the Florida Department of Law Enforcement, which is an accredited lab that conducts ballistics examinations. And it's not just looking at a shell casing and looking at another one from the eye and saying, oh, they're both Winchester, they match. This is microscopic comparisons done by an individual who is trained and who looks at these microscopic comparisons, comparing one to the other and making a determination at these markings that are placed on the shell casings when the bullet is fired, when it ejects out of the firearm, comparing those, as well as comparing markings on the projectile that is shot through the barrel of the gun. She looks at the markings left on these pieces of evidence to make determinations as to whether or not they came from the same firearm, and sometimes if they came from a particular firearm. So you will hear testimony that she had projectiles from the scene in this case, .45 caliber projectiles that were recovered from the 604 Ocean Mist Court. She had shell casings that were left behind at 604 Ocean Mist Court, and that she determined that those shell casings all matched as having come from the same firearm, and that the projectiles that were left at the scene, the .45 caliber projectiles, all came from the same firearm. She ultimately also compared the shell casing from the burn pit off of the defendant's property as matching the shell casings from Ocean Mist Court, and that the projectile from the shooting target on the Keetley property matched the projectile from the projectiles at Ocean Mist Court. She is not able to say if they in fact came from the Glock 21 that Mr. Keetley owned, because that was never recovered. She will also tell you that the shell casings match coming from a Glock. She is not able to tell you that the projectiles came from a Glock. How is that possible? That is possible, and as the case unfolds and the evidence is presented, that if someone changes the barrel, places a aftermarket barrel on the firearm, it won't, and it's not, if it's not a Glock, so basically you have a Glock firearm, you change the barrel to an aftermarket barrel, those projectiles will not match as having come from a Glock, because it's a change that has been made. And when ballistic comparisons are done, firearms are very specific and unique, and they make unique characteristics, grooves, markings on these projectiles and shell casings. And so if something is changed from being the manufactured barrel on the Glock to an aftermarket barrel, they're not going to match. You will hear also testimony from the victims in this case that when they observed this firearm, they all describe it as a long gun, not a short gun that a Glock is. A Glock is a handgun. They describe it as a long gun, which they describe also as they saw a pump action done by the gunman when he approached the porch and when he began shooting, execution style, victim after victim after victim. You will hear, since Mr. Wesley Smith and Michael Keetley had this love for guns, that they spoke about gun shows that they would go to. They spoke about attachments that can be placed on guns. They spoke about modification kits. A modification kit that was new in 2010 that Michael Keetley spoke to Mr. Smith about, because it was going to make it easier for Mr. Keetley to shoot the firearm. Because after he sustained his injury from the robbery, he could still shoot a firearm, as you're going to hear testimony from the witnesses, just not as easily as he could before that injury. And so you will hear that this modification kit that Mr. Smith and Michael Keetley discussed is a modification kit where a Glock is slid up into this.
We object. Can we approach? Yes.
testimony throughout this case about conversations that Mr. Smith had with Mr. Keetley regarding firearms. In addition to all of the ballistic evidence in this case, and how I previously discussed with you how the aftermarket barrel could be attached to a Glock, and how that projectile, Miss Clark cannot say came from the Glock. You will also hear evidence in this case that multiple searches were found on Michael Keetley's laptop computer regarding aftermarket barrel attachments. As law enforcement continues on with their investigation after conducting multiple interviews, collecting multiple pieces of evidence in this case, following lead after lead, sending evidence off ultimately for testing, they also learn that the day after the shootings, Michael Keetley takes his father's van to be painted, to have the color of his father's dark colored minivan changed. So on November 26th, Michael Keetley makes contact with Mr. Henry Bose. Mr. Henry Bose, who lives in Tarpon Springs and conducts a car painting business out of his home. And Mr. Keetley arrives at Mr. Bose's home. Mr. Bose not there, but Miss Carrie Bose is, and she was not expecting Mr. Keetley that day, the day after Thanksgiving. And she usually, if customers are going to be coming to their home, since the business is out of their home, Mr. Bose will tell her when customers are going to be arriving. Mr. Keetley arrives at their property with this dark colored minivan that is all solid dark blue. Mr. Bose is not there, so Mr. Keetley proceeds to clean out the inside of his van. Even though the inside of his van is not going to be painted, the outside of his van is going to be painted. He cleans out the inside of his van, where multiple bags of trash are taken out and placed where the Bose family keeps their trash. He then also begins to wash the outside of his vehicle that's about to be sanded down and painted. And he assists Mr. Bose in all of this. He assists Mr. Bose in sanding down the vehicle with a handheld sander. And he and Mr. Bose work until the late hours, going into Saturday morning. And Mr. Keetley stays there and helps him work on this vehicle. He doesn't drop the car off, go home, and come back and pick the car up when it's painted. He stays there all night. He in fact sleeps on the couch waiting for the vehicle to be done. And the plan was to change the vehicle color. It was going to become no longer one solid color. It was going to be two-toned. So it was navy on top and it was a tan bottom. And this was done the day immediately preceding the shootings. He, in fact, wakes up Mr. Keetley and unwraps the vehicle himself the next morning after he was done sleeping at the Bose home and after he had completed helping Mr. Bose with the job that he had hired him to do. Ultimately, ladies and gentlemen, the surviving innocent victims in this case will take the witness stand and tell you exactly what they remember happening to them those early morning hours of that Thanksgiving morning. That the pieces of evidence that were seen at Ocean Miss Court corroborate the victim's statements. That there was one gunman with one gun, and those projectiles matched a projectile taken from the defendant's property, and those shell casings found at Ocean Miss Court matched the shell casing in the burn pit at the Keetley property. And that the defendant was obsessed with getting revenge on the individual that he thought that robbed him. he was going to get revenge on November 25th, 2010. And the state's confident that at the conclusion of this case, you will find the defendant, Michael Keetley, guilty as to all charges. Thank you.
Thank you, Ms. Johnson. Ladies and gentlemen of the jury, we're going to go ahead and take our morning break at this time before we hear the opening from the defense. Please remember all of my previous instructions to you, and I re-instruct you at this time that you are not to discuss this case amongst yourselves or with anyone else. You are also not to do any research related to this case in any way, shape, or form. I say that we're going to take a short break, but I know that there are 15 of you and there is one restroom in that jury room. So it'll be as soon as you all are ready to come back in, we'll bring you back in and we will proceed. All rise for the jury. Jury has exited. Everyone may be seated, and the door is closed. So go ahead and set up whatever you need to for the defense opening. I'm telling you that it's going to take at least 20 minutes, but my intention is to come back in maybe just a little bit short of 20 minutes. Maybe they'll surprise me, but the bailiffs will also let me know if they're ready sooner than that. But as I told them, the break is as long as they need. I'm sure that that's going to be more than enough time for you to set up your opening, your equipment for your opening. My thought is we'll see how long it takes, but we'll see. It's 10, so if we get back at 10:30, 11:30, I don't know whether we'll be able to do a witness before lunch break. We'll see where we're at, and if necessary, I'll have you all approach to make a decision whether you call your first witness or not after the defense opening. All right, thank you. Defense ready?
Yes, sir. Yes.
I really think that we'll be doing our lunch break after the opening state. I don't think you had a short witness your first witness, short, long, medium?
It's not super long.
Well, I may have y'all, yeah, we're ready. I may have y'all come up then before I make that decision. We'll see how long, because we don't know, but I'll have y'all come up before we make a decision. Let's bring them in. Everyone else may be seated this time. Ladies and gentlemen of the jury, welcome back. I hope everyone had a nice break. We're going to turn to the defense now to have their opening statement, but before we do that, was anybody exposed to anything about the case or discuss anything about the case during the break by show of hands? Let the record reflect there are no hands. Again, thank you all very much. We'll now turn to the defense.
I told you we would have a response. And here it comes. But first, let me tell you what we agree with. We agree with the government when they say that on November 25 of 2010, a terrible crime occurred here in Hillsborough County. And we agree with the government when they tell you that Juan and Sergio Detron died and that 4 others were shot. And we agree with the government when they come and tell you that it was wrong and it was criminal. But they say Michael Keetley did it. They say Michael Keetley is responsible. They have picked up the heavy hand of blame and pointed it at Michael Keetley. Folks, that is where our agreement ends. Michael Keetley is not guilty because he did not do it. Now, you just heard from Miss Johnson for some time, and she told you some facts, and this is my chance to tell you what we believe the facts will be, okay? And we take issue with some of the things that they mentioned in their opening statement. And we take issue that there are some things that they did not tell you in this opening statement. And for that, I'm grateful for a response. We went last week a long time in jury selection, and when we did, we talked to you about this idea of presumed innocent. That when you sit here, you are presumed innocent. But at some point it was suggested until. Unless the government proves its case beyond to the exclusion of each and every reasonable doubt. Remember how we talked about the father who presumes that his son or his daughter did something without seeing? And that we said we don't want to presume guilt in any situation. It's not fair to start here at this table. Remember how we said as a father or a parent that maybe will stand here in the middle.
I'm going to object this to argument. These are opening statements.
I'm going to caution Mr. Grant not to argue the case. Save it for closing. Let's talk about what you believe the facts will be in the case.
As you hear the evidence, you don't stand in the middle. As you hear the evidence, you are to presume that he is innocent. And Michael Keetley is here today to let each and every one of you know that he is not guilty of what these prosecutors say he is. So let's get to work. When we talk about this case, the government will have to prove their case beyond and to the exclusion of each and every reasonable doubt. As you have heard already in jury selection, a reasonable doubt can come from a lack of evidence, a conflict in the evidence, and the evidence itself. When you hear the testimony today, you, and throughout the time we're together, you can, and you should, consider what's missing, what conflicts, and what you hear. And as you do, the courtroom will fill with reasonable doubt, even though it only takes one doubt that is reasonable. In bringing these charges, the government has the obligation to prove every element of their crimes. Michael Keetley has to prove nothing, but we have stuff to say. Michael Keetley stands here ready to face what they bring.
Judge,
They have to
object
prove.
this to argument. These are opening statements.
I'm going to sustain at this point, Mr. Grant. Let's move on to what you believe the evidence will show. Let's avoid any argument in the opening statement.
Sure. Sorry, Judge. The evidence will show that they have to prove every element of the case, and they have to do it beyond a reasonable doubt. So, before we get to Thanksgiving morning of 2010, we have to go back in time. The prosecutor argued that this is a case of obsession, about vengeance and revenge. We need to tell you about January 23rd of 2010. For while they said it's evidence of his motivation to commit a terrible crime, in reality the evidence will show irrefutably that he could not do what they've accused. On that day, Michael Keetley, as he had many times before, drove his purple ice cream truck throughout Ruskin, throughout Waimama, throughout Old Sun City Center. Michael Keetley was known. Michael Keetley was known. That ocean mist address, he'd been up and down and around that many a time. On this January 23rd, what happened was someone flagged him down, a woman, and he stopped. Do you want ice cream? Do you want nachos? She wanted his money, and she had two people to help him get it. They did not tell you that the people who put a gun to him were wearing ski masks. And they did not tell you that all he could see was their eyes. They wanted everything. They gave him everything. All $12. And then they shot him. And then they shot him again. And then they shot him again. And then they shot him again. I don't think it's even possible to explain or understand how Michael Keetley was able to get to that driving in the driver's seat.
Objection, Judge Goldenwolf.
Well, Mr. Grant, rephrase.
Fine. I don't think the facts will show exactly how he got in that driver's seat and was able to drive himself to safety. But somehow he did. And somehow he got help. And somehow he got taken to Tampa General Hospital. Michael Keetley arrived with shots to his leg, chest, shoulder, and hand. No one wants to be in the condition that Michael Keetley was on January 23rd. But if you are, you want to have David Halpern on call. David Halpern is the chief of plastic surgery for Tampa General Hospital. David Halpern was on call. David Halpern operated on Michael Keetley on January 24. David Halpern has a specialty in the area of the hand. And what the prosecutors did not tell you was the extent of the injuries. David Halpern is going to come before you on March 14. And Ms. Kahn is going to ask him questions. And Ms. Kahn will help guide Dr. Halpern to educate you on what was going on with Michael Keetley, what his condition was, specifically and especially as it related to the hand. It's important for you to know that as a result of what happened to him on January 23rd of 2010, Michael Keetley was left with a pronounced limp. And the hand, they're going to use a word called comminuted fracture. Basically, that means when the bullet goes in, it just doesn't break in one or two places. It is the worst kind of injury. Sometimes you can't even put the bone back together again. And there are nerves that are attached. And Michael Keetley went through his first surgery on January 24, 2010. It would not be the last. He would have surgery again in March. He would have surgery again in June. You're going to hear a phrase called radial nerve palsy. And that simply means Michael Keetley's radial nerve, which goes from your shoulder through your arm, down to your hand, to your fingers and your thumbs, it wasn't working properly. That's what you're going to hear. And that really the only thing that could be done was to see if there would be some response over time. The radial nerve, as Dr. Halpern will tell you, is the only nerve that allows us to extend our wrist, our fingers, and our thumb. Without the radial nerve functioning properly, the person cannot extend their wrist. Without the radial nerve functioning properly, a person cannot extend their fingers. And without the radial nerve functioning properly, a person cannot extend their thumb. The question will be asked, Dr. Halpern, was the injury to Michael Keetley's hand significant? This will be the answer. It was majorly significant. It was majorly significant. So what does this mean? Dr. Halpern will tell you that what this means is that he did not have function to be able to do this. He could not. The only thing that could be done were some exercises to try to see if he would get some use, but that was over time. Here's a picture that Dr. Halpern will give you. He will say when someone goes into a room and turns on the light switch and the electricity doesn't go and the light doesn't turn on, that can be frustrating if you're entering a room. It can be very frustrating when it's your hand. The light switch will flick, but nothing would respond. Every 3 months, Michael Keetley would go for a test. A big fancy word will be used. EMG. I'm going to give you the letters because I have a hard time pronouncing it. It's a test that cannot be faked. It's a test that cannot be cheated. It cannot be gamed. Michael Keetley would have electronic stimulus put on his hand and his arm, and they would see if there was any response. The last test done on Michael Keetley, November of 2010, November 1. The results: no recovery, no improvement since the last one in June. The switch is being flicked, but electricity is not going through, and the light is not going on. And that's Michael Keetley, medically. Let's talk about what you'll hear practically. When Michael Keetley got out of the hospital in 2010, his life had changed. He could no longer live on his own. He moved in with his parents. He slept in a hospital bed. He wore Velcro shoes because he could not tie his shoes. He could not cut his meat. He could not always wipe himself. This is Michael Keetley. In order for Michael Keetley to do anything, he has to think about it. Brushing his teeth requires thought and planning. Things that are taken for granted do not happen. Now, I'm going to tell you, there'll be a couple of people probably come in, a couple of ex-girlfriends. They'll say, we didn't really notice anything. David Beckwith and Wesley Smith, you've heard about one, and you'll meet the other. Yeah, he was shooting guns. They'll say everything was fine. Directly conflicting the medical testimony. Hear me, please, and hear me clearly. Dr. Halpern has not gotten a check. Dr. Halpern is not paid.
Judge, I'm going to object this to argument.
I'll sustain. Mr. Grant, avoid argument. Just talk about the facts.
The evidence will show that Dr. Halpern was the treating doctor of Michael Keetley, not looking over anybody else's work. And he will refute them over and again. Because, see, the right hand and the left hand have to work together. He cannot do things separately and independently. That's what Dr. Halpern will tell you. In order to do this, he first must do this. And when he's got his hand open, he now must, I'll move it over here. He now must That's Michael Keetley in 2010. The hand is not his only disability. All of this is going to be important for you because you're going to have to realize that medically, irrefutably, the evidence will show that his movements are slow. They are deliberate. They are awkward. They are uncoordinated. Spoiler alert, like nothing any of these people on the porch will describe. That's Michael Keetley. And furthermore, Michael Keetley had been in that neighborhood. So this is our defense. Michael Keetley is not guilty because he did not do it. He did not do it. He could not do it. He is not medically capable. So now let's talk a little bit as the calendar is turned and January becomes February, and Michael Keetley is a motivated victim. There's no question about that. I expect that we'll talk to Detective Noland, and when we asked Detective Noland, he wanted to know who did this. He was shot. He was left for dead. He called, and he called. And you know what? What they told you the evidence will be is not correct. Michael Keetley described the people who did this as black, dark complected. The detective never once considered that Hispanics can be dark complected or light complected. And when Mr. Keetley called them, he was saying the word on the street is that this was Hispanics who did this. Ruskin, Waimama, Old Sun City Center has a heavy Hispanic population. Michael Keetley never once backed off of his identification. He said, "This is what I'm hearing out there. Will you please go check it out?" And without question, you will learn that Michael Keetley wanted to have the person who did this to him caught, not killed. Crime Stoppers was involved. Rewards were offered. He put it on his truck as he drove throughout Ruskin. Do you know? Have you heard? What have you seen? That will be the evidence. He was motivated. He was interested. And when he heard something, he called. And when he called, they did nothing. Nothing. He gave them names. He gave them anything and everything he had. And you know what they said? "Stop interfering, sir. Let us do our work, sir." And to some extent, as the evidence will come out, and we'll ask Detective Nolan, the reason why you do that is you don't want to pollute a victim or a witness. You saw what you saw. Let's not use word on the street. Let's not use something that could contaminate you. To a certain extent, we can understand that. They told you that Michael Keetley was angry. They did not tell you the whole truth. Yes, Michael Keetley, the evidence will show, is that guy. You want to buy a nacho? Have you heard who shot me? He was preoccupied with that. There's going to be no question. They'll put a TV story on it where he says, "I want the people who did this to me to suffer like I did." He'll say that. And he'll even say in a statement with Detective Schramm, we'll talk about him. Detective Schramm, you know what he says? "I went through that. I processed that. That's in the rearview mirror. You may hear from a guy named Luciano Alonso. He's got a restaurant. Michael Keetley eats there. They talked. Nobody ever called. No evidence will be brought to say he's out there threatening people. If they produce someone by the name of Armando Guerra, listen very closely, because Armando Guerra will say, if he testifies, that Michael Keetley said I was involved with the shooting. Do you know what Michael Keetley did? He held out his wrist. He held out his hand. He said, it doesn't work anymore. This is what happened to me. Not once will there be a threat. Not once will there be a weapon. Because you know what the evidence is? Michael Keetley is Ruskin. Michael Keetley is Waimama. And the state's own witnesses will tell you that the people of Ruskin were fond of Michael Keetley, and Michael Keetley was fond of the people of Ruskin. You want to run a tab? Okay. You want to pay me back slowly? If at all? Okay. Over and again, Michael Keetley had involved himself in the community. That's the evidence. He was there all the time. And that is very significant to this case. Oh, and by the way, you know what one of the other emotions he expressed was? Thought I was going to die, but I feel like God gave me a second chance.
Objection, Judge.
Approve.
When he was talking with Norma Towers, he thought that he'd been given a second chance by God. If they're going to bring in evidence in this case that suggests that it was all anger all the time, that is not correct, and we will confront that. They talked to you about Creeper. And they talked to you about that being Omar Bailon. Never once was the name Juan Gatron, and never once will there be any evidence that Juan Gatron was a part of what happened to Michael Keetley in January of 2010. No evidence of Sergio Gatron being involved, or Daniel Beltran, or Gonzalo Guevara, or Jose Rodriguez, or Ramon Galan, or Richard Cantu. Never once had their names or any nicknames. Gonzalo goes by Gonzo, for example. Hadn't come up. And so now we can talk about Thanksgiving of 2010. And let's make something very clear. These people are victims. And what happened was awful. 2 are dead. 1 cannot speak for himself. 3 will testify in person. 1 will come by video. And I want to let you know, we will have to ask them questions. When all is said and done that night on the porch, hanging out, playing cards, drinking beer, somewhere between 50 to 60 beers are consumed. Several marijuana blunts are smoked. Someone goes out and gets cocaine, and some of them take bumps or hits off of cocaine. And that's the evidence. And by the way, when we talk to you about them, please, that is not to say we don't like them and neither should you. Not at all. You have to be put in their place to gauge their perception. And that's why we will talk with them. And that's why we will show them and every witness respect. But there are questions that need to be asked, and they will be answered. And here is what we have. 2 people are going to come in. I say come in. 1 by video and 1 in person. 2 people are going to come in, and they are going to say, Michael Keetley is the one who shot me. That's what they're going to say.
Objection, Judge? May we approach?
Absolutely.
As I mentioned, 2 people will come in here and identify Michael Keetley. Jose Rodriguez will testify by video replay and say Michael Keetley was the shooter. Gonzalo Guevara will come in here and say Michael Keetley is the shooter. So it seems like there's really nothing to question. I want you to anticipate testimony from Dr. Jennifer Dysert. She will be called by the defense. Like Dr. Halpern, she is very skilled. She is very credentialed in her field. And she deals with the issues of identification that people make. Dr. Dysert will testify about a couple of things. One, she will testify about something called estimator variables. And these are factors related to the witness and their opportunity to see a perpetrator at the time of a crime and to make a correct identification. When you hear from her, you may want to have your notepad ready. I can't obviously tell you what to do, but there are certain factors that she will talk about. One, she will talk about duration, the time to see the events. In other words, as she will say, the more you see, the more you can be accurate. Now, when Ms. Johnson talked to you, she blended the statements together into a narrative that is cohesive. But that's not how it works. We're going to step witness by witness very quickly. And in fact, there is conflict in their statements and testimony that you will hear. To some extent, that can be expected. Now, what everyone will agree on is that this was a quick event. It happened fast. And it happened in seconds. We'll talk about this so much, you may think, man, this is an event that took as long as jury selection, but that's just not true. It was quick and it was gone. That's the second thing that you will hear. Not only is there duration, but there's exposure, the ability to see the events. And not only was it quick, it was dark. The evidence will be that there is no street light in front of Ocean Mist. There was only one small porch light. A shadow comes, a shadow shoots, a shadow goes. Dr. Dysert will ask you to consider weapon focus. Was the witness focusing on the gun? Again, there will be conflict in how this shooting occurred. For example, Gonzalo Guevara will say a first shot was done in the air, while Ramon Galan will say, no, that first shot hit me. But on this, almost all agree that a black pump-action shotgun was used. A black pump-action shotgun. Black pump-action shotgun. That's what was used. Daniel Beltran and Jose Rodriguez should tell you that after each shot, the shooter had to rack and shoot. Rack and shoot using two hands. Dr. Dysert will ask you to look at stress and high arousal, the ability to see something sudden, to encode it and process it. Not only process it, to accurately store it so that when you tell it again in the future, you are actually telling something correctly. She will talk about own group or own race bias. It's not a pejorative. It's not racist. It's that certain people in certain groups are easily able to identify within their own group. It could be age. It could be color. You have cross-race identification in this case, in that they claim it was a white person who did it. Alcohol and intoxication. It should be obvious, but Dr. Dysert will talk to you about that. That can have the ability to affect someone. And the issue, lastly, is going to be on prior familiarity. Hold your ticket stub for a minute. We'll come back to that. I want to talk to you quickly about these witnesses. Ramon Galan started the night at his cousin's house, hanging out with his cousin Rosemary. Juan Gatron was there. Richard Cantu was there. Richard Cantu was driving. Ramon probably had 4 or 5 beers there at some point in time. They leave Rosemary's. They go to a gas station. They get a 12-pack of beer, and they come over to Ocean Mist. Ocean Mist is a dark street. The lighting is, as Mr. Galone will tell you, just a porch light. Where the porch light was lit up, but like the road and the yard, it's dark. After a while, they decided they were going to go back to Rosemary's. So Ramon Galan is on the step. Is that good for you?
Can you move it to the side a little bit? I want to be able to see the jury. I don't need to see the screen. That's fine.
I'm trying to see it. We're going to show you the step in just a second. But as you do, to be good with your time, Ramon Galan is at the bottom on the first step. He all of a sudden hears somebody. He's going to be right about here. And for the record, I'm pointing at the bottom first step on the right as you're facing the picture. Everybody else is up on the porch. He's waiting for Juan. He's waiting for Richard so that they can go back to Rosemary's. And at some point in time, up comes a person who says, give me your ID. Try that again. Give me your IDs. He turns and he is shot. That's the first shot. It was 1 to 2 seconds. He could not tell ethnicity. He will not be able to tell voice, height, weight. It's a silhouette. Doesn't know anything. He just remembers being asked for his ID, nothing about Creeper, and being shot. That's Ramon Galan. Daniel Beltran will arrive at this place, Ocean Mist, around 7 o'clock. He's with his buddy Diego Lucas. Diego Lucas is not on the porch when this happens. Diego Lucas is going to be inside this house. There are people inside this house who are asleep. None of them see anything. They may hear some stuff, but they're not eyewitnesses to what happened. He's not sure how cocaine gets introduced on the porch, but he's going to use it. He smoked marijuana. He drank beer. He's going to say that he saw a minivan, and despite what Ramon Galan says, apparently they all talk about it. Hey, there's a minivan driving. The car leaves and then comes back, and now it parks somewhere in front. And by the way, this does not give you a great idea of the situation, because this is lit up by sheriff lights. This is dark. And this is not many feet from the road. It is very close to the road. Daniel Beltran will say that the shooter was between 6'1" and 6'2" inches. That the shooter was wearing black boots that were laced up. That the shooter was 250 to 280 pounds. A big guy. That's who the shooter is. Daniel Beltran was facing the house when this started, because when he says he was told to get down on his knees, he did, and he faced away. And the shooting was loud, and the shooting was quick. He describes a pump-action shotgun, black, knows it for a fact, holding the gun with both hands. The trigger and the stock is in his right hand. The barrel is in his left. Since it was a pump action, had to shoot and pump between rounds. Everyone but Juan was facing away. He will say that the shooter tried to kick him or others after he was shooting. And yes, he will agree this was just a matter of seconds and that Ocean Mist is, in fact, a very dark street. This takes us to Jose Rodriguez. Jose Rodriguez was on the porch. He was not shot. Listen carefully when you see his cross-examination today. He will have to be corrected on several occasions. More than once, he'll have to look at prior statements. He will be the only one to claim that the shooter arrived in a van and was playing loud rap music. The shooter? Large. 6'1" to 6'2", 250 to 270 pounds. This is happening fast. He will be another one to tell you this. It is undisputed that he was drinking, smoking marijuana, and snorting cocaine. And now we have to tell you more about Jose Rodriguez. This happens around 2:20, a couple minutes after in the morning. The police come. The police talk to him. First, and he will say this both to the prosecutor and on cross-examination to the defense, he, in spite of all of this, has the wherewithal to mislead the police. Listen for it. People are hurt, being airlifted, and he will say, don't know nothing about creeper. Watch for it, because it will come. And Jose Rodriguez was asked initially, and you know what his response was when they talked about the shooter? I have never seen this man before in my life. I have never seen this man before in my life. Police will get a series of photos, including Michael Keetley's picture, and a deputy or other officer not involved in the investigation. He will show him the photographs. Michael Keetley involved in that. And you know what Jose Rodriguez does? Doesn't pick out Michael Keetley. So the evidence will show drove through that neighborhood round and round in his purple ice cream truck. Jose Rodriguez has been on that porch just feet away when Michael Keetley stopped. Jose Rodriguez has been on that porch as he's watched his kids buy ice cream, nachos, whatever. Maybe not even always having to pay. Jose Rodriguez, on 8 to 10 occasions, has said, I bought from that guy. I have never seen this man before in my life. So what changes? Well, very shortly after 2 o'clock in the morning, a text is sent out. This is a text that will change everything. To borrow from James Thurber, this is where confusion will get its foot in the door. This is the guy who shot Magic and Spider. I don't know what that word is. If anyone sees him, the cops are looking for him. It's the same guy who got shot in OSC, Old Sun City Center. He was the ice cream man back in January. Where did this come from? I don't know. It was forwarded and 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 forwarded. I didn't think I could say that many times. A man named Juan Hernandez, who heard about the shooting, within 2 hours or so, comes to Ocean Mist. And then he's later going to look on his phone. He gets the text. A cascade of unreliability and suggestiveness begins right here. Because you know what Juan Hernandez does? He goes to Jose Rodriguez. You know that guy? Yeah, it's the ice cream man. He's the shooter. And so now, under that, Michael Keetley did it. The ice cream man. Name the investigation, name the case, based on a text. Can I tell you something? Do you want to know where that text originated? Do you? So do I. Police never followed it up. It went through Riverview, it went through Ruskin, it went through my mama, can you believe it? It went to Texas. A state witness by the name of Carol Orduno may testify. She got the text. It's going everywhere. Michael Keetley did it. And when Juan Hernandez says, I'm not going to tell you where I got it, the lead detective in this case says, okay. Curious that this text is going out. As the evidence will show, there was no eyewitness. Jose Rodriguez had not given a full statement. Gonzalo Guevara is in the hospital. He will not talk for days. Daniel Beltran, he's in serious condition as well. There are no home cameras or surveillance footage. No one on the porch spoke to law enforcement besides Jose Rodriguez, who said, I have never seen that man before in my life. One picture changes his tune. So that is why we're going to argue that this is a case of misidentification. And that is why we will cross-examine these people. So let's talk about Gonzalo Guevara. He cuts hair all day. He was on his feet. He doesn't really want to go out, but his friend kept saying, and finally goes, okay. He goes out with Sergio. He goes out with Walter Lucas, again, someone who lives in the house but is not a witness to what happened. He has seen the purple truck frequently. He knows Jose has bought from the purple truck frequently. He would see this in person. He says he didn't really pay attention. And he was on the porch, which I think he estimates anywhere between 40 to 50 feet away. A little bit more than a first down in football. He has a dark minivan showing up, a man getting out, looking nervous. He describes this person as a chunkier dude like him, but a little taller, like way taller than me. Gonzalo Guevara is 5'9", 225. This man is 4 to 5 inches taller than him. This man is 280, maybe 290, maybe 300 pounds. To use the words that Gonzalo Guevara has used before, he's got a chunky, fat body. Significantly, Gonzalo Guevara is going to say, this man walked up. Oh, by the way, Jose Rodriguez, my bad, I forgot. Do you know what this shooter did? According to Jose Rodriguez, he speed walked. Walked up real quick, walked up real slow. No limp. Nobody's going to talk to you at all about any physical disability. Nothing unusual about the hand. No uncoordination. This is a fat, overweight, chunky guy who did this, and he did it quickly. He did it in the dark. That is going to be their evidence. That is going to be their testimony. Gonzalo Guevara has the shooter with the gun in a left hand. and a badge-like thing in his right. Significantly, Gonzalo Guevara is going to say the shooter fired a warning shot in the air. And he did it with his right hand. So somehow that gun will get from the left hand, the badge will be put away, and the gun will get in the right hand and it will shoot. That is going to be Gonzalo Guevara's testimony. And let me tell you, when Gonzalo Guevara goes to the hospital, I'm about to say good for him, not good for him, but good for him that he has supportive family. People come, sisters, brothers. The neighborhood is talking. Everything happens so quick. That's what Gonzalo Guevara will say when he has a chance to speak. No physical disability. Just overweight. Just not in shape. Had brown orange hair. Prescription cone glasses. Had the black pump action shotgun. He's going to describe some type of vest being worn. As you hear the evidence in this case, I'm going to ask you to wait again for Dr. Halpern. The evidence will show Michael Keetley does not have the speed, agility, dexterity, or coordination to do what their victims say was done. Let's also talk about Gonzalo Guevara. This is something significant. In jury selection, we talked about rules, we talked about procedures. You're not going to be surprised to hear that Hillsborough County Sheriff, they have rules, they have procedures, they have standard operating procedures. This is going to be significant. How do you do an eyewitness procedure? I want you to keep in mind that what happened with Jose Rodriguez originally was blind administration. An independent administrator administered a test not knowing the desired answer. This person would not be aware which person in the photos or lineup is a suspect, and would eliminate the possibility of unintentionally influencing the witness's selection. The guidelines set forth in this standard operating procedure will be used The guidelines will be used, or shall be used, under various circumstances when dealing with eyewitnesses. Eyewitnesses play a vital role in solving crimes, where in some cases the only evidence that may exist is the testimony of an eyewitness. It is also important to keep in mind that eyewitness testimony may exonerate innocent parties. Procedures surrounding the police lineup have remained unchanged, but research and DNA exonerations have proven that eyewitness ID can be somewhat flawed and should be handled more effectively. It is the intent of the Hillsborough County Sheriff's Office to seek more reliable procedures for eyewitness identification and ultimately mitigate potential misidentification. That is the rule. Why did I tell you that? Because the lead detective in this case, Jose Lugo, did not follow these rules. He specifically and willfully chose to break policy. And what he's going to say when that text message is already out there, he's going to come by the hospital and he wants to show photographs to Gonzalo Guevara. And the medical people are going to say, not today, he's hallucinating. And he comes in and he says, I'm going to come back tomorrow. And he goes, oh, sorry, show me today. His family's in there. He's like, no, I'm going to show you tomorrow. You remember my name, Jose Lugo. That's what he's going to say. And you know what happens? The next day, they demonstrate a photo array. The next day, they demonstrate a photo array. And now, Gonzalo Guevara is going to say that he is 2,000% positive. There's going to be quite a bit of discussion about this right here, this 3/4. So I want you to preview for that Gonzalo Guevara originally picked 4, then it was changed to 3, and the 4 there. There's a lot of question mark about how this was done. We know it was in violation of the rules, and we know it was done sloppily. What we will also hear from the evidence is it was not recorded, so you cannot see it. You cannot hear it. He identifies Michael Keetley by 2,000%. Even though Michael Keetley has never been anywhere near 300 pounds, even though he's never been anywhere close to or over 6'2". The 2 eyewitnesses in this case will be based on identification of a man who's been coming through that neighborhood for years. So by now you're not surprised to hear we're going to challenge every bit of the state's evidence. And we will brush away things that will not need to be challenged. Don't be scared. I could stay up here for a lot longer. There's going to be cross-examination. Wesley Smith, he shot on that property. Wesley Smith, there's a lot to say about him because what they say he said, he waited a long time to say. He cannot tell you specifically what, he cannot tell you specifically when, and it was only after he started watching the news and the news and the news and the news. And David Beckwith, they didn't tell you he's a convicted felon who put a gun to Michael Keetley's head, a .45 to Michael Keetley's head. Took off with the gun. They told you about painting a van, changing the van. The bumper was two-toned for resale value. They talked to you about a change of a barrel or modification. They will not have one witness come in to say that Michael Keetley ever did that. I'm going to ask you to keep in mind when you hear the government's questions. For Ms. Johnson got up here and talked about computer searches. She says that Michael Keetley made all these searches. The truth is, they cannot show that Michael Keetley ever made one. The truth is, they were selective in what they wanted Michael to be searched. And they cannot even tell you what it means or put it in context. So yes, Michael Keetley or others used that family computer. And yes, Michael Keetley was interested in finding out who shot him. I have to address something last, because they talked about a statement that Michael Keetley made, that he denied Creeper. True. He knows Creeper. True. Doesn't seem like he told the truth. True. Michael Keetley is Ruskin. Michael Keetley is Old Sun City 7. Michael Keetley is Waimama. And there's a text going around that says he did something he did not do. How do you defend yourself? Because they didn't put it in perspective. They stopped
Judge,
him.
I'm going to object this argument.
I'll sustain. Mr. Grant, leave it to the facts and not conclusions related to those facts.
Here's the evidence. They said that he gave a statement. What they didn't tell you is they pulled him over that night. The police did. On the road for an hour, Detective David Schramm comes up to him, not recorded, and says, hey, let's go back to the sheriff's station. Let's do an interview. We want to talk to you about the case where you were a victim. That's what we want to talk about. He goes there without a phone, without transport. He's taken to the station. They put him in a room. They talk to him about the case. And they say things like, hey, judge me for me. We're not going to BS you. They talk with him a little bit. The first statement ends at the station. And he goes and sits outside for 45 minutes. No car, no phone. David Schramm sees him, says, I'm going back to your house. I'll give you a ride. On the way back, another discussion is had. And in that other discussion, there are things said by David Schramm. And what are they telling him? They start saying, we think you did this. We know you're the one who committed this crime. They say to him, we've been planning to get a search warrant since 10 o'clock this morning. David Schramm will have to admit that's not true. They say Detective Schramm and his partner, they say, we've got someone who puts you at the scene. That's not true. They say, we're going to take over your case. We're going to find out who did what happened to you. That's not true. They say, we have phone records which put you at the scene of the crime. That is not only not true. Michael Keetley says, terrific. If you've got my cell phone records, you can know where I am. Do it! They never will. They never do. They have the ability, and they do not do it. That is what the evidence will be. Detective Schramm says, we've got somebody who can describe you to a T. However, he does not fit the height, he does not fit the weight, he does not fit the hair color. They even say they've got his actual work glasses that they've recovered. Time and again, the police use what they may call tools or strategic questioning, but what are really intentional misrepresentation and deceptions to get him to say, you did it. And consistently he says, no, I did not. So there's a lot to come. And the time to question witnesses begins now. I'm going to ask you to I'm going to ask you to presume Michael Keetley not guilty, presume him innocent because he's not guilty. I'm going to ask you to listen to the evidence and hear the testimony, and because of what is lacking and because of what is conflicting and because of what there is only one conclusion that you must draw, and that is that Michael Keetley is not guilty of all counts.
Let me have the attorneys approach briefly. The attorneys, I have decided that since it is a couple minutes till noon, it is a perfect time to take our lunch break. I will instruct you not to discuss this case amongst yourselves or with anyone else, also not to do any research, and to avoid any reports of this case outside of the courtroom. I am going to give you until 1:15. We will return at that time, and we will turn to the state for the first witness. All rise for the jury. Watch your step coming down those stairs and that chair. If you want to push it, there you go. Everyone may be seated. So we'll come back at 1:15. State, I'm sure you've got witnesses here that we can start calling. And, the plan is we'll take an afternoon break. It'll probably be about 3, but sometime between 3 and 3:30, and then go up to as close as 5 as we need to. I told them I'd try to get them out at 5. Obviously, there's a witness on the stand. I've warned them about that. But the plan is, since we started at 9 and got started pretty close to on time today, and we're not in any situation we're trying to make up time, that we'll let them go at or before 5 o'clock, if at all possible.
That's fine, Judge.
All right. Anything from either side? Have a nice lunch. I'll see you all at 1:15.
Where we can go ahead and start calling witnesses. With Jose Rodriguez's testimony, I think there's a couple of things that defense and the state want to address maybe on the record regarding how we're going to label that prior testimony. Additionally, it looks like the version that was sent by defense, because they took the logos off, it's got, when you either pause and hover over it, it'll say Court TV testimony portions deleted. So what we're trying to figure out right now is how defense can send that to us in a format that we can attempt to remove all of that so that it can be published today. But I think in the meantime, we can go ahead with witness testimony.
All right, let's do that. And I know that you all had agreed on an instruction, so I have to find it when you play those. I think there's the edited recording instruction, but I don't think I gave the other instruction that I said I would give, that they're not to be concerned about prior testimony. There was an instruction that you all agreed upon on that.
The one they emailed me last week.
Yes.
I don't think that's necessary right now, but I know I got something that said that you all had agreed. That's where I said I'm not going to tell them that there was a mistrial, but I would tell them that there was prior, they're not to be concerned about. Whatever you all agreed upon eventually needs to be given to them. I think the best time to give it to them is right before you play your first prior testimony.
Okay, that's fine.
And I'll also give, if appropriate, edited recording instruction.
The other thing, if the court wants to address it now, I know previously we have had prior testimony labeled as a court exhibit because it's not a state exhibit. It is not going back with the jury when they deliberate.
It should not.
I know that defense is objecting to it being labeled as a court exhibit for the concern that the jury is going to give it more weight coming from the court instead of the state.
Oh, well, you don't have to say that in front of the difference is that it's not going to go back to them, which it should not, just like transcripts of testimony.
I don't care what you call it as long as you don't call it in front of the jury.
Court's
exhibit. Because
I hear you, and I have no problem.
Okay.
Maybe if you want to call it item number, we'll exchange, instead of court exhibit 1, 2, or 3, whatever there is item number 1, item number 2.
Yeah, because at the end of the day, the jury's got to know that they're the one that's presenting this particular witness. It's former testimony. They're presenting it on their case. And so, they're going to be calling up, which is what I've done before, they're going to be calling up, Jose Rodriguez. And Jose Rodriguez is going to be in the form of a video.
Okay, well, actually, we don't have to call it any exhibit in front of them. But when we introduce it so that it's in the record, we just do that outside the presence of the jury as court exhibits.
Perfect.
So we won't refer to it as an exhibit at all. The testimony of the next witness.
That's it?
Okay.
Perfect.
All right.
Works for the state. Thank you.
All right, so you got witnesses, live witnesses ready to go?
We do.
Defense ready?
Yes, Your Honor.
Let's get the jury. May be seated at this time. Ladies and gentlemen of the jury, good afternoon. Welcome back. As you probably have guessed, my first question to you is, was anyone exposed to anything, or did anyone discuss anything about this case between the time that you left before lunch and the time that you returned, now by a show of hands? Let the record reflect there are no hands. Again, thank you all very much. I will now turn to the state and ask them to please call their first witness.
State calls Corporal Christopher McMurtry.
Corporal say that for me again?
McMurtry.
McMurtry. Welcome. If you'll come forward to be sworn as a witness where the bailiff has indicated, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do.
Thank you, Corporal. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. When you get to the chair at the end, go ahead and have a seat. Make yourself comfortable. That microphone in front of you is adjustable. All right. You may proceed.
Thank you, Your Honor. Please state your full name for the record and spell your last name for the court reporter.
My name's Christopher McMurtry. Last name is spelled M-C-M-U-R-T-R-Y.
How are you employed?
I'm a law enforcement corporal with the Hillsborough County Sheriff's Office.
How long have you been with the Hillsborough County Sheriff's Office?
16 years.
And you said now you are corporal, is that correct?
Yes.
I want to talk to you about January 23rd of 2010. What was your position back on that day?
I was a law enforcement deputy.
Okay. And what was your assignment as a law enforcement deputy back on January 23rd of 2010?
I was a patrol deputy in Apollo Beach, Riverview, Waimama, Ruskin area.
Okay. And are all of those cities located here in Hillsborough County?
Yes, they are.
And where are they in reference to Tampa in Hillsborough County?
South County.
Okay, so the southern part of Hillsborough County, is that correct?
Yes, ma'am.
Okay. And that's the area you were assigned to?
Yes.
On January 23rd of 2010, did you respond to the location of 4225 Old Highway North?
Old Highway 41?
41, I'm sorry.
Yes.
And where is that located in Hillsborough County?
Ruskin.
And when you arrived, why did you go to that location?
For a shooting call.
Approximately what time did you arrive at that location?
Somewhere around 6:57
Is that 6:57 at night?
p.m.
PM in the
Yeah.
evening. Is it still light or dark out at that point?
It was getting dark.
When you arrive at that location, what are your observations when you get there?
There was an ice cream truck in the driveway, and in the driver's seat there was a male who had been shot, and there was some blood throughout the various spots within the ice cream truck.
Do you remember the color of the ice cream truck? Was it a truck or a van?
Van style.
And do you remember the color of it?
Yeah, I believe it was purple.
And you said that there was a gentleman, I think you said, in the driver's seat. Is that correct?
Yeah, he was in the front.
And could you tell at that point that he had been injured?
Yeah, it appeared he probably had about 3 gunshot wounds, I believe.
Was he bleeding at that time?
Yes.
Did you, what did you do when you got there?
I went to give first aid and secure the scene. Fire rescue arrived maybe about a minute after me and took over first aid. So I really didn't get a very close look at any of his injuries.
And when you say first aid, you mean to the person who was injured in the driver's seat, is that correct?
Yes.
Was that person later identified to be Michael Keetley?
Yes.
Is he present in the courtroom today?
Yes.
Can you please point him out and describe what he's wearing?
He's sitting over here wearing a white shirt and like a tan cardigan.
Your Honor, may the record reflect he's identified the defendant?
The record shall so reflect.
Did you, you said that you started to render first aid, is that correct?
Yeah, I went over that, yes, to assist.
At some point, did you call or did some other deputies call for an ambulance or for fire rescue to respond?
Yes.
How long did it take for fire rescue to get on scene?
They were on scene about a minute after me.
And did they immediately take over the medical treatment of the defendant, Michael Keetley, in this case?
Yes.
What did you do at that point?
That's when I began to survey the scene and establish a crime scene perimeter.
And what would have been the crime scene perimeter?
That's where we put up crime scene tape to prevent anyone to enter or exit without proper authority.
Was the van that Mr. Keetley was driving, was that parked in front of a residence?
Yeah, it was in a driveway.
Were there some witnesses that were associated with that driveway that were eventually interviewed?
Yes.
Did you conduct any of those interviews?
I don't believe maybe one. I'm not quite certain.
Okay. Maybe one of the neighborhood. Looking at your report, help refresh your recollection?
Yes.
So I'm going to show you a copy of your report. It starts down there. Can you take a look at that and review it and tell me when you're done reviewing it, read it to yourself when you're done reviewing it, whether or not that refreshes your recollection as to whether or not you interviewed any witnesses in the case? Did you have an opportunity to review that?
Yes.
Does it help refresh your recollection?
Yes.
Was there any of the witnesses back on January 23rd of 2010 that you had interviewed?
Yes, there was one.
Okay. And who was that?
Narcisco Maya?
Okay. And was she a neighbor from that residence where that van was parked?
Yes, from my understanding, yes.
Okay. At some point, was the defendant taken to the hospital?
Yes.
Prior to Mr. Keetley being taken to the hospital, did you put out an alert?
Yes.
What is an alert?
It's like a be on the lookout for the suspects, where we get a description of the suspects and we place it out so other units who are in there you can try and locate them.
So prior to Mr. Keetley being removed to go to the hospital for treatment for his injuries, did you or other responding deputies obtain a description of the suspects involved in this case?
Yes.
Okay. How many persons were involved?
3.
Okay. And did you get a description for each one of those potential suspects, those 3 individuals?
Yes.
Okay. And let's start with, were they all male or female or a combination of that?
It was a combination.
Okay. Tell us what he told you, how many were involved, and what type of sex they were.
From my understanding, it was black female and 2 black males.
Okay. Was he able to provide any sort of description of a possible vehicle that may have been associated with these suspects?
Yes. It was a Buick Century, I believe.
And was he able to give any sort of clothing descriptions of any of the perpetrators?
I remember the clothing description of the female was pants, I believe a white shirt, and I believe a tan jacket.
What about the 2 male subjects?
I'm not remembering their 2 descriptions with their clothing right now.
Did he mention whether or not any of their faces had been covered?
I do remember one of them having a mask.
Okay. Did you remember one of them or both of the male subjects?
Specifically remember at least one male had a mask on.
Okay. And as soon as that description, you obtained descriptions from the victim in that case, Mr. Keetley, did you put that information out over the radio?
Yeah, that information goes out over the radio.
And who does that information go to? What is a BOLO? You said be on the lookout for. Is that correct?
Yes, exactly.
And who does that go to? Who's that radio to?
It's related over the radio to other law enforcement officers with the sheriff's office, and depending on where our dispatch sends it to, they could send it to other law enforcement officers throughout the county and state.
And is that information that you want to get out as quickly as possible?
Yes.
Okay. And was Mr. Keetley, was an in-depth interview done with him on the scene by you?
No.
Why not?
Because fire rescue was giving him medical aid.
At some point in a case like this, would a crime scene detective be assigned to do any sort of follow-up work?
Crime scene and a detective, yes, both.
Did crime scene investigators go to that scene to start processing the scene and document it?
Yes.
Was that van, Mr. Keetley's van, was that impounded and collected for evidence?
Yes.
Did you do anything additional during the course of that investigation into the robbery of Mr. Keetley?
Not that I really specifically recall.
Were there other deputies on scene that were also responded to that location?
Yes.
And were they also doing other investigations, such as taking a neighborhood survey?
Yes.
Did you do anything else in furtherance of that case?
No.
Now I want to ask you about I want to fast forward to November 25th of 2010. Were you also working on that day in November, Thanksgiving?
Yes.
Okay. Were you working on that day?
Yes.
Okay. Did you respond to 604 Ocean Miss Court?
Yes.
Is that also located here in Hillsborough County?
Yes.
When did you respond to that location?
At approximately, I believe, 2:29 a.m.
That's in the early morning hours, is that correct?
Yes.
And was that the early morning hours of Thanksgiving Day?
I believe it was Thanksgiving Day, yes.
What did you do when you first responded to that area, to 604 Ocean Miss Court?
I parked my car, exited, and began to walk up to the scene.
What kind of vehicle were you driving on that day?
I was driving a marked police vehicle.
And how were you dressed?
Similarly today, white shirt, green pants, gun belt, badge.
Okay. Similarly to how you're dressed today?
Yes.
Okay. Complete white shirt with your Hillsborough County Sheriff's Office insignia clearly marked on your shoulders, is that correct?
Yes.
As well as a star on your chest?
Yes.
Okay. You responded to that location. Did you come into contact with any individuals the moment that you parked your vehicle?
Yes, there was like a small crowd that approached me.
Okay. Without saying whether or not they said anything to you, did they alert you to a specific address?
Yes.
What address did they alert you to?
I believe it was 604 Ocean Mist.
What did you do at that time?
That's when I went approached the porch, and I saw that there were several victims. Based on what I was seeing, I actually started to physically count, and I counted 4 what appeared to be victims of gunshot wounds on the porch, and then another just inside the front door, and I relayed this information to dispatch so we could get additional medical units en route.
So you said you saw what appeared to be 4 victims, is that correct?
Yes.
And you said of apparent gunshot wounds.
That's what it appeared to be.
Can you please describe to the jury what you were seeing that led you to believe that they were gunshot wounds?
There was a large amount of, there was blood on the ground. Everybody was screaming in pain. It was very chaotic.
And you said you actually started counting them, is that correct?
Yes, I remember having to count 1, 2, 3, 4. I paused for a second, evaluated further, and then that's when I recognized there was another person just inside the front door.
So a total of 5 at that point, is that correct?
Yes.
At that point, were you doing anything on your radio?
Yeah, I was relaying information about what I needed at the scene for medical aid, and then also trying to get out information on what had happened.
At that point, had any of those individuals that had been injured said anything about what happened while you were up there on the porch counting?
From my understanding, they had been shot with like a shotgun or something similar.
Did they say by who?
Someone dressed in a police costume.
I'm going to show you what's been marked for identification, States Exhibit 5A, B, and C. Do you recognize these photographs?
I do.
And do those photographs fairly and accurately depict that porch and that address, 604 Ocean Mist Court, on November 25th of 2010?
Yes.
Your Honor, at this time we'd introduce into evidence States Exhibit 5A, B, and C.
Any objection?
Just see.
Take them. Yes. All right. 5A, states 5A, B, and C is admitted at this time.
Corporal McMurtry, can you see that? I think you also have a monitor. Or maybe you don't. I apologize. You can see the giant screen right up there.
Correct.
Can you tell us what this shows in 5A?
That's going to be 604 Ocean Mist, and that's going to be the porch and then the front door where I located everybody at.
Okay. And now I'm going to show you 5B. And hold on one second. Is that a closer up of that Ocean Mist address, 604 Ocean Mist Court, as well as the porch?
Yes, exactly.
And you had said that there were 4 that were located on that porch, is that correct?
Yeah, I remember 4 being on that porch. Correct.
And where was the 5th person?
Just inside that front door there. That's
Okay, and
open.
kind of, I'm pointing to the center of the door. The door is open. He was located, you said, just inside that doorway, is that correct?
Yes.
Okay. At some point, was there another victim? Were you alerted to the presence of another victim?
Yes.
Can you tell us how that occurred?
I got alerted over my police radio that there was another victim just down the street, and I went over there.
Okay. And when you went down the street, can you tell us what you observed or who you came into contact with?
I came in contact with another deputy, Deputy Velasquez, and I'm not sure who the victim was.
Okay. Did that victim appear to have any sort of injury?
I don't recall.
Okay. Did you do anything with regards to that particular victim?
No.
I want to go back to that porchway. At some point, did you assist in putting up crime scene tape, securing the scene?
Yes, I did.
Prior to you being able to do that, had there been additional deputies up on that porch?
Yes, there were several deputies that arrived to assist me.
Had you been up on that porch?
Yes.
Had fire rescue and medical personnel been up on that porch?
Yes, absolutely.
Had there been others that had been in the home or people that you first made contact with who had at one time been on the porch?
Yes, I believe so.
At some point, you secured the scene, is that correct, with the assistance of other deputies from the Hillsborough County Sheriff's Office?
Yes.
And after the scene is secured and victims are removed, is anyone else allowed to then go up on that porch until it has all been processed?
No.
How long did it take for fire rescue to respond after you put out that initial alert?
They responded very quickly, within minutes.
And eventually, were there victims that had been removed from the porch,
Yes.
as well as the victim from the house?
From my understanding, yes.
Okay. Were all of the victims removed except for one?
Yes, from my understanding, I believe so.
Were you the first responding Hillsborough County Sheriff's Office unit to respond?
To this scene?
Yes.
Yes, I arrived on first, and then everyone arrived after me.
Can you remember approximately how many law enforcement officers, Hillsborough County Sheriff's deputies responded to that scene?
In total?
Just an estimate.
Several. If I had more than 10.
And you were in a marked vehicle, is that correct?
Yes.
Were there other deputies that had responded in marked vehicles?
Yes.
Okay. Were all of the law enforcement officers that responded, were they with the Hillsborough County Sheriff's Office?
From my understanding, I believe so, yes.
That was within your jurisdiction, is that correct? This location 604 Ocean Miss Court, that was within the Hillsborough County Sheriff's Office jurisdiction?
Yes.
Your Honor, may I have one moment?
Yes.
Ask the witness.
All right. Cross-examination?
Yes, Your Honor. Good afternoon, Corporal.
Good afternoon.
I'm going to walk you through the two different incidents that you just described with Miss Doherty and separate it the same way so we can make sure that we're following along, okay?
Okay.
So I want to start with January 2010. You arrived on scene where you learned Michael Keetley was shot and robbed, correct?
Yes.
And I believe you mentioned that upon arrival, very shortly after, within minutes, Mr. Keetley was taken into the hospital.
Yes.
At that time, you were able to observe the purple ice cream truck
Yes.
and all the blood within, correct?
Yes.
And it was obvious to you, even in that brief interaction, that he had multiple gunshot wounds.
Yes.
I believe that you previously testified you were able to obtain a description. However, that description was not given to you directly by Mr. Keetley, correct?
I'm not sure if it was directly for him or from a fellow officer.
Okay. But within that short time, that was the only opportunity you had with Mr. Keetley, correct?
Yes.
Throughout your investigation, you also were able to determine that the robbery itself occurred in a different location, correct?
Yeah, it was a few houses down, from my understanding.
A short distance, but you were able to go and evaluate that scene just the same as you did where the ice cream truck was, correct?
Correct.
And in evaluating that scene, you were able to observe a shell casing, correct?
Yes.
And blood that was outside of the ice cream truck, even though Mr. Keetley was found within.
Yes.
And obviously, through your training and your experience, whenever you find something unusual, especially something that could potentially connect to a crime scene, you point it out to fellow officers, crime scene techs for collection, correct?
Yes.
And you did so in this case.
Yep.
And correct me if I'm wrong, but at that point that concluded your investigation, correct?
For the most part, yes.
So I want to move to the November 2010 shooting. You were a patrol deputy in District 4, correct?
Correct.
I'm going to show you what I've pre-marked as Defense Exhibit 1. If I may approach?
Yes.
Thank you. Do you recognize that area to be an aerial view of Ruskin and the jurisdiction for District 4?
Yes, I'm familiar with all this area.
Are you able to see the District 4 office and, again, the Ruskin area in which it encompasses?
Some of the Ruskin area, yes.
Does that fairly and accurately depict that area in which District 4, that portion in which District 4 has jurisdiction?
Yes.
Your Honor, if I may approach and move into evidence, Defense Exhibit number 1.
Is there any objection to Defense 1?
No objection, Judge.
Defense 1 will be admitted at this time.
And Your Honor, if I may also pull the large screen to display that exhibit.
You may. Are you going to need the witness to step down where he...
Yes, Your Honor, it might be better once we move it so that there's no cords in this area. Is that okay, Your Honor?
It's okay with me, yes. I just want to make sure that the jury can see the witness, though.
Yes, Your Honor, I would ask the witness to step down.
All right.
On this side, I can get out of the way so that he can point.
You step down, absolutely.
And Corporal, this is the photo I just showed you. I just wanted to be able to zoom it up. If you could just point.
And I don't mean to interrupt you, but there is a yardstick up here that we often use as a pointer, if that's of any assistance. You may use
Absolutely.
it.
Thank you. If you could please point, and if needed, I can zoom it in for you as well. District 4.
Okay. That's what here.
And that was the office in which you worked at the time, and this was the jurisdiction of District 4 in the Ruskin area, correct?
Yes.
And then just across the street, there was at that time a gas station. At that time, it was a racetrack, correct?
Yes, right here.
Within close proximity, that was an area in which patrol deputies would often wait while on patrol, correct?
Yeah, I would go there occasionally.
Given the close proximity.
Yes.
It's not labeled on the map specifically, however, there are other local businesses on that. I believe it's within East College Ave and Sun City, correct?
Yes.
And going back to the first incident, which I described in January,
Yes.
in which Mr. Keetley was robbed and shot. That is not pictured on this map, correct?
That is correct. It's not on this.
Could you point to the general area in which that would have been?
It would have been over in this general area somewhere.
So southwest
Yes.
of the map. Okay. And then can you please point to the area in which you arrived for the November 2010 shooting?
It would have been here on Ocean Miss Court.
And that's where 604 Ocean Miss Court is, correct?
Yes.
All right, you can have a seat, thank you. So again, on November 25th of 2010, you were working your usual shift when you got a call to the shooting, correct?
Yes.
I know you said it was early morning hours. Do you remember what time it was?
I arrived there at approximately 2:29, I believe. 2:29 a.m.
2:29 a.m.?
Yeah.
Approximately?
Yes.
And the call indicated that this was a multiple victim shooting, correct?
That's the way I understood it.
And you were familiar to this area of Ocean Miss Court prior to this call, correct?
Yes.
You were aware of local drug activity,
Yes.
and you are aware that this is an area that has gang activity as well, correct?
Yes.
And given this information, just like any call to service, especially when a shooting is involved, you're using everything that you know when you're approaching the scene.
Yes, you use your experience and training.
And obviously, upon arrival, you're assessing for officer safety and potentially the other people that are around, correct?
Yes.
And when you arrive on scene, you arrive first. Is that correct?
Yes, I arrived first.
And it is extremely dark. I know that there was a photo that was presented by the prosecution, but that's not what it looked like when you arrived, correct?
There's the occasional street light in the area, but it is darker.
So maybe one street light, but that photo does not depict how it looked upon your observation, because that photo has illuminated lights, correct?
Yeah, that photo does have illumination.
So whenever crime scene or other deputies are taking photos, especially in the middle of the night, they're going to have large illumination in order to capture what you would be able to see, correct?
Yes, they use lights to illuminate that area.
But before those lights come on, dark.
Yeah, it was darker than those photos, yes.
So dark that you're not able to see everything until you get close, correct?
Depends. I also used my flashlight.
Okay, in this case, it was so dark you had to use your flashlight?
Yeah, I definitely used my flashlight at some points.
And upon arrival, a crowd of people approached you to advise that there had been a shooting, correct?
Yes.
I know you mentioned that there was a description in your previous testimony that you obtained, but this description you obtained was from that crowd of people, not the victims, correct?
Of what had happened?
of what had happened, who this person looked like. This was a description you received from the crowd of people that approached your vehicle.
It was a combination of everybody involved, if I remember correctly.
Oh, do you recall taking a deposition in this case?
Yes.
And the deposition that you took was on August 29th, 2011.
Sounds correct.
At the state attorney's office, defense attorneys, prosecution are present, and you're placed under oath, correct?
Yes.
And again, today's testimony was that you received this description from the victims on the porch, correct?
I believe that's what it said, yes.
Okay, and for the record, this is page 10, line 15, starting at line 14. You were asked, okay, and then what happened? You answered, I tried getting a brief description of what happened. That's when I learned that the suspect was possibly dressed in a police costume, armed with what was described almost to be like a shotgun. Question, who were you getting this description from? Answer, from all the people standing around, there was a large crowd gathering.
Okay.
Do you remember saying that?
That sounds accurate.
And you also mentioned that this scene was chaotic.
It was.
So obviously you're getting a lot of information from a lot of different people.
Yes.
And at this time, your goal, your focus, isn't preserving evidence. It's assessing the scene, correct?
My first goal is to make the scene safe.
Officer safety, that was going to be my next thing. Officer safety and safety for those around you, correct?
Yes.
And therefore, you're not really tiptoeing around the area. You're managing what you deem to be most important in that moment, correct?
Yes.
If I may have a moment, Your Honor.
Yes.
Thank you.
Are you ready?
Yes, briefly. Barbara, when the defense counsel asked you about your prior deposition and who were some of the people that in that crowd giving you that information, did you also say that the victims were also present and yelling information at you?
Yes, I believe so.
And as far as would you describe that scene as somewhat chaotic?
Yes.
And was your first priority at that time getting medical attention to those victims?
Yes.
Were there how would you describe their injuries at that point?
Severe.
And were there other sheriff's deputies that were there as well assisting you in that investigation?
Absolutely.
And after ambulance had responded, were you then able to then turn your attention to securing the crime scene?
Yes.
Prior to securing the crime scene, what had been your focus?
To make the scene safe and provide first aid.
I have nothing further to add.
Will this witness be released or subject to recall?
He may be released.
And by the defense, released or subject to recall?
Oh, subject to recall, Your Honor.
All right, you may step down, but not released at this time. No need for him to remain outside, though, today, correct?
No, Your Honor.
All right, thank you. And I'll ask the state to please call your next witness.
The state calls retired Detective Nolan.
Retired Detective Nolan. Detective Nolan, good afternoon and welcome. Wherever you're comfortable, if you'll face me and raise your right hand to be sworn as a witness. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Detective, you'll follow the billet to the ramp that leads up to the witness chair. Please watch your step. Go ahead, have a seat, make yourself comfortable. That microphone in front of you adjusts. You may proceed.
Please state your full name for the record.
Roy Nolan, I go by Ron.
Did you used to work for the Hillsborough County Sheriff's Office?
Yes, ma'am.
When did you retire?
June 25th of 2010.
Prior to retiring in June of 2010, how long had you worked for the Hillsborough County Sheriff's Office?
28 years.
I'm sorry?
28 years.
28 years. When you were working in 2010, what was your position and what unit had you been assigned to?
I worked the Criminal Investigation Division, the robbery unit.
And I want to ask you specifically about a robbery involving the victim, Michael Keetley, that occurred January 23rd of 2010. Are you familiar with that investigation?
Yes, ma'am.
And were you assigned to conduct follow-up investigation as a case detective?
Yes, ma'am.
When were you assigned as that case detective in the robbery investigation involving the victim, Michael Keetley?
January the 25th, 2010.
So that would have been approximately about 2 days after the offense. Is that correct?
Yes, ma'am.
As part of your investigation as a case detective, did you review and have access to all of the police reports of the first responding deputies?
Yes, ma'am.
Is that something that you looked at in order to conduct your follow-up investigation?
Yes, ma'am.
Did you yourself interview the victim in that case, Michael Keetley?
Yes, ma'am.
When did that interview occur?
The next day would be the 26th of January at Temple General Hospital.
And is Michael Keetley, is he present in the courtroom today?
Yes, ma'am.
Can you point him out and describe what he's wearing?
Excuse the interruption, Judge. For the record, we would stipulate that this witness can in fact identify Michael Keetley.
Well, that's fine to stipulate to. Do you accept the stipulation that he's
Yes,
identified
Judge.
him? All right.
That's fine, Judge.
All right.
And so a person that you became aware of was named Michael Keetley. You met with him at the Tampa General Hospital. Is that correct?
Yes, ma'am.
And I'm sorry, what day did you meet with him?
26th of January, 2010.
When you met with him, how was he doing at that point?
He was in the hospital bed. I interviewed him. He had no problem answering questions.
Jack, lack of foundation.
Hold on. With him, he was answering my questions. Rephrase.
When you were interviewing Mr. Keetley, did he appear to understand the questions that you were asking him?
Yes, ma'am.
Did he appear lucid?
No, ma'am.
What do you mean he did not appear to be lucid?
He had no problem answering my questions. I mean, he was coherent.
All right, maybe I asked it incorrectly.
Okay.
Did he appear to be coherent?
Yes, ma'am.
Okay. And when you were interviewing him, did you explain to him why you were there?
Yes, ma'am. I explained that I was a case detective who was going to be investigating his case, the robbery.
Was Mr. Keetley, was he able to provide you with a detailed statement at that time as to what happened to him back on January 23rd of 2010?
Yes, ma'am.
And what did he tell you?
You want the whole statement or you just want a synopsis?
Give us a synopsis and then I'll ask you some more detailed questions.
Okay. Synopsis was he was selling ice cream out of the ice cream truck in the area of known as Old Sun City, which is south of Ruskin, Florida. He noticed the car had pulled up behind him, honking the horn. So he stopped thinking they wanted to buy some ice cream. He stated a light-skinned black female, very well dressed, got out and asked him how much was a soda. So he told him that at that time he noticed that a black male had gotten into his truck armed with a weapon, covered, face was covered, he had on knit gloves. Didn't notice another black male, and he also had the gun, also had his face covered, wearing knit gloves. He asked him not to steal his truck. He said, "We're not there to steal your truck." One of them, the black male, shot him, and then they fled in what he described as a Skylark or Buick Century. And they went, witnesses said they went south on Highway 41 towards Manatee County.
So he has described 3 suspects, is that correct?
Yes, ma'am.
One of them was a black female.
Yes, ma'am.
Jack, leading, counsel testifying.
I'll sustain, don't lead the witness.
The information that Mr. Keetley provided to you in the hospital, did you have the opportunity to also review description information that he provided to first responders?
That's correct.
Was it consistent?
Yes, ma'am.
Did an alert go out, a BOLO, a be on the lookout, go out immediately after the crime had been taken place on January 23rd of 2010?
There was a written.
May we approach the bench?
Sure.
Retired Detective Nolan, I believe I asked you whether or not you had previously familiarized yourself with the first responding reports that were done in this case.
Yes, ma'am.
Prior to interviewing Mr. Keetley, did you acquaint yourself and review all of the supplements that were done by the first responding deputies?
Yes, ma'am.
And you yourself conducted your own detailed interview of Mr. Keetley at the hospital, is that correct?
Yes, ma'am.
Did you review the information, the initial descriptions that Mr. Keetley provided to those first responders?
Yes, ma'am, I did.
Did you see whether or not a be on the lookout BOLO, as what it's commonly referred to, was put out as an alert by those first responding deputies?
I don't remember if they put out an alert. I don't remember that.
Okay. Did you yourself put out an alert?
Yes, ma'am.
Okay. What type of an alert did you put out?
I put out a written alert, which is distributed to what we call Zone 5, which is 5 counties. And they get our alerts. I also put out a statewide alert through our communications.
Okay. Prior to putting out your alert to this 5-county wide
Zone 5. Mm-hmm.
Zone 5, did you put in the descriptions that were provided by Mr. Keetley?
Yes.
And I want to take this one description at a time. Let's start with the black female. What was the description provided by Mr. Keetley and provided in your alert to the other zones, those 5 counties?
Yes, ma'am. The black female was described as a black female in her 20s, 5'10" in height, weighing approximately 200 pounds, with a large belt. She had a medium complexion, shoulder length, curly black hair, and brown eyes. Was last seen wearing a tan jacket, tan pants, and a white T-shirt.
And was all of that information provided to you from Mr. Keetley?
When I interviewed him, I had a written alert, and I went over the alert with him, and he agreed to what I had in the alert.
Now I want to ask about the 2 black male suspects. What was the description of the person that he believed was the shooter, the one with the gun?
Well, they both had guns.
They both had guns.
Okay. The second suspect, the shooter, was described as the black male, 20 to 25 years of age, 5'10", 165 pounds, with a thin build. He was medium complexion, brown eyes. He's wearing a black T-shirt, black ski mask, and had on black knit gloves.
And what about the third subject, the third armed black male subject?
Third suspect was described as a black male, unknown age, 5'7" in height, weighing approximately 215 pounds, with a large belt. He had medium complexion, brown eyes. He was last seen wearing blue-green flannel shirt and a black ski mask.
Did your alert also contain details about the vehicle that they were seen in?
Yes, ma'am. The vehicle was described as a 1990s white Buick Century. In the deputy's report, he also said Skylark, 4-door with dark tinted windows and 2 small donut spare tires. And I got a photograph of a car similar, and I put that in the alert.
Okay. And you said that was distributed to multiple counties, is that correct?
Yes, ma'am.
As your role as a follow-up investigator, what else did you do in this particular case?
I investigated since the car was seen fleeing south on 41. I contacted the Palomino Police Department, Manatee County Sheriff's Office, to see if they had any similar robberies, which turned negative. They were negative.
What else did you do in this case?
I received calls from Mr. Keetley about some information that he received.
Okay, I'm going to ask you about that in a second.
Okay.
Was there any sort of latent investigation, fingerprints, DNA, stuff of that nature that was done in this case?
Yes, ma'am. They're all negative.
And in this case, would the victim's description of these both armed men wearing gloves, would that be surprising for you as to negative for fingerprints?
Yes, correct.
other than the victim that was bleeding, were there any descriptions ever given of any of those black males that entered into his van of being injured in any way?
No, ma'am.
Okay, now I want to talk to you about those phone conversations. Do you remember approximately how many times you received some phone calls from Mr. Keetley after your initial interview of him in the hospital on January 26th of 22?
There was approximately 3 to 4 phone calls.
Tell us about those 3 to 4 phone calls that you received.
He would call me and tell me that during his route selling ice cream, that the word on the street, they were Mexican males who did the robbery who shot him.
I want to stop you right there. He, at that point, told you that he was back working. Is that correct? He's back on his ice cream route?
Yes, ma'am.
Okay. And when he said that word on the street, was he able to ever provide you with a witness for you to talk to when he called you?
No, ma'am.
Other than word on the street, he provided you with no eyewitness?
Object, leading, counsel testifying.
Rephrase it.
Based on the phone conversations that you had with Mr. Keetley, were you ever provided with an eyewitness that you could actually interview?
No, ma'am.
Were you actually provided with a witness that overheard Mr. Keetley making statements?
No, ma'am.
Did he ever give you the name of a witness and an address?
No, ma'am.
Now, you said that he had, at that point when he was talking about this word on the street, that he had said, what was the ethnic background of the people who had robbed him? What was the word on the street?
Mexican males.
Okay. Did you express any concern with him once he said that?
Yes, ma'am.
Okay. And what did you state to him at that
I
point?
told Mr. Keetley that changing the description of the suspects will most likely hurt this case. Since you gave me black males and a black female, now you're telling me they're Mexican males.
Did at any point in any of those conversations, did Mr. Keetley indicate to you that he in fact wanted to change his description of who was involved in his case?
I don't know if he did or not, ma'am.
Okay. Did he, would you have changed, would you have made a supplement to your police report if the victim in a case had stated that he wanted to change the description?
Yes, ma'am.
Okay. Did you do that in this case?
No, ma'am.
Okay. And you said that there were how many phone conversations?
Possibly 3 to 4.
3 to 4. And any of those 4 conversations, did he provide you with the name of an actual witness for you to talk to?
No, ma'am.
Based on those 3 to 4 conversations that he had with you, was there anything for you to be able to follow up with any sort of latent investigation?
He might have gave me a couple of nicknames, which I did some follow-up, but nicknames are hard to find the real person who the nickname belongs to. If a person comes in contact with law enforcement and they give a nickname and the real name, that information is put into the computer. So if I run a nickname, that name is going to pop up. None of the names that he gave me, and I don't remember who they were, never came up.
Okay. And so you don't remember what those nicknames were, is that correct?
No, ma'am.
Okay. Did you write any sort of supplement to document what those nicknames were?
No, ma'am.
Okay. Would you have done that if you had gotten anything as a lead based on a nickname?
That's correct.
Your Honor, at this time we pass the witness.
Good afternoon, Detective.
Good afternoon, sir.
Is it all right if I just call you Detective instead of retired detective?
Nah, that's fine.
Loosen the syllables here. All right, so let's start with this. Did I hear you say you retired when?
June the 25th, 2010.
All right, so you're going to retire 6 months after this investigation begins. Is
That's
that right?
correct. Yes, sir.
You're already in the last stages of your career in January? You had a fixed retirement date, didn't you?
I didn't make the final decision until after January.
Right. So this case, when you left, was still open.
Yes, sir.
All right. So let's see if we've got the groundwork correct. This event occurs on January 23rd.
Yes, sir.
You get notified, I'm going to say you, Detective Nolan, you get notified on the 25th.
I was assigned the case on 25th.
Right. Typically how this works is, as is the case, then Deputy McMurtry, he's the deputy that responds, right?
Yes, sir.
So typically a call like this goes out, road deputies or uniformed deputies will respond first, right?
Yes, sir.
And given the circumstances of case, that may involve the need for a crime scene detective to come out
Yes, sir.
and crime scene technicians to come out.
Yes, sir.
And you are aware that Mr. Keetley was shot more than once, right?
Yes, sir.
How many times was he shot?
I think 3 times.
Where was he shot?
In the stomach and chest area.
Where else?
That's all I remember. The stomach area. Stomach area.
Stomach area? What about the leg?
I don't remember that.
What about a hand?
I don't remember that.
What were the nature of his injuries?
Gunshot wound.
Okay. I got it. But when he went to the hospital, did he go to surgery?
I don't know if he did or not.
Okay. You talked to him on the 26th.
Yes, sir.
And you told us that, first you said he wasn't lucid, but then I think maybe you misunderstood the question. You
Right.
said he was coherent, right?
Yes, sir.
Were you aware that he had a major surgery on January 24th?
I don't remember
Do
that.
you know the name of the doctor who did his surgery?
No, sir.
Do you know the extent of his injuries? How severe? Whether they were permanent?
No, sir.
What do you specifically remember when you were in the hospital room when you saw him about his bandaging or his dressing?
I don't understand what you're asking me.
Well, he was still in the hospital, yes?
Yes.
All right. Did you talk to, I know you say you didn't talk to the doctor, or I think I heard you say you did not talk to the doctor.
That's
Did I get that correct?
That's correct.
Did you talk to any medical personnel?
No, no, sir.
Did you see or check to see whether he was under the influence of any medication, such as morphine or anything else?
No, sir.
So when you talked to him, you made your own independent determination that he was lucid and coherent, right?
Correct.
Okay. What time of day was this that you talked to him?
May I refer to my report, please? .30 in the morning, 9:30 a.m.
Okay. Was anybody else with you?
As far as police?
Yes, sir.
No, sir.
Just you?
Yes.
Did you record this interview?
No, sir.
How long did this interview last?
15, 20 minutes maybe?
Okay. When you put an interview together, there are two ways, generally, that I'm familiar with the Hillsborough County Sheriff's does it. One is a recorded interview, right?
Correct.
And Hillsborough County Sheriffs have transcriptionists who will then put a transcript together. This is the question you asked, this is the answer, right?
That's correct.
And that is a way to document exactly what a particular witness, suspect, or in this case, victim says, right?
Yes, sir.
We would agree that Michael Keetley was a victim.
That's correct.
We would agree that a gunshot wound can be a very serious injury.
Yes, sir.
Multiple gunshot wounds.
Yes, sir.
Are you familiar with the phrase comminuted injury or comminuted break?
No, sir.
Okay. So then you would not be aware that's where a bone breaks in multiple places?
I wouldn't know that, no, sir.
Okay. If you talked to Dr. Halpern, you would have learned that he would have had.
Objection, Your Honor.
Just sustained. Okay. We can agree you didn't talk to Dr. Halpern to see the extent of the injuries.
That's correct.
Okay. And what procedures he had undergone, right?
That's correct.
When was he released from the hospital?
I don't know that.
You didn't follow up on that?
I didn't follow him being released, no, sir.
Okay. You didn't follow up on his medical records?
No, sir.
Can we agree that this would be a case that could involve something called great bodily harm or serious bodily injury? You're familiar with that in criminal law, right?
Yes, sir.
And what is that?
When somebody's injured, it could be near death or, like you said, great bodily injury.
Did Michael Keetley have great bodily injury?
I guess he did, yes, sir.
I'm not asking you to guess, please.
Okay.
Do you know if he had great bodily injury?
I didn't know at the time, no, sir.
Do you know now?
After you told me, yes, sir.
I didn't tell you. I asked a question.
Objection, Your Honor. His answer is what his answer is, Judge.
It's cross-examination, so we will.
I asked you a question. I want to know what you know.
I didn't know he had great bodily injury, no, sir.
You did not know that, right?
Correct.
That would be serious to know, right?
I guess so, yes, sir.
Well, if someone is under the influence of medication or someone has serious bodily injury, that could affect the quality of the statement they give. Would you agree with me on that?
Yes, sir.
All right? So someone could be answering questions or giving you information, but it may or may not be good and accurate information. Would you agree with me on that?
Yes.
Okay? And so before you got the statement from Michael Keetley, you did not check his medication status, right?
I don't remember if I did or not.
Okay? And you don't remember if you checked what his great bodily injury or other great bodily harm, serious bodily injury or great bodily harm status is, correct?
No, sir. No, sir.
So he gave you descriptions, right?
Yes, sir.
Each of these people, and he uses the phrase black,
Yes, sir.
right? And we use that in society, white, black, and Hispanic, right?
Yes, sir.
But you would agree with me that we also use the phrase when we talk about Hispanic people, about people who are Hispanic black or Hispanic white, right?
Yes, sir.
That, much like all of us, we have different pigmentation, right?
Yes, sir.
Okay? Even people who would be classified as white. Some are darker brown than others, right?
Yes.
So when he says that these were black people, okay, he then was further able to tell you they were of medium complexion, right?
Yes, sir.
Now, as far as the two people who did this to him, he only saw their eyes. Is that correct?
He had a mask on, yes, sir. That's
Correct. They had a mask on, right?
Yes, sir.
So when he's telling you it's a black male, it could have also been an Hispanic black male, right?
I'm just going to what he told me with black males.
I understand what he told you.
Yes, sir.
But you agree that oftentimes you have to follow up on information that victims or witnesses tell you, right?
That's correct.
Oftentimes victims or witnesses can tell you things and they can be honest in their attempt, but they can tell you things that are incorrect, right?
Yes, sir.
Okay? So we're not certainly going to necessarily accept something that comes from a victim or a witness just because they say it, right? You have to follow up on it, right?
Well, I followed up. I did an investigation and I put in what he told me they were black males. Yes, sir.
5'10", 165 pounds. That was one of them, apparently, right?
Yes, sir.
The other was 5'7", about 250 pounds, right?
215 pounds?
15, 1-5, sorry.
Yes, sir. Yes,
I'll
sir.
get better diction there. 215.
2.5. Yes, sir.
Got it?
215. Yes, sir.
You agree with me on that?
Yes, sir.
Now, you did say that you requested latent prints on the scene, right?
Yes, sir.
Now, I think you said it was not a surprise to have a negative result because these people who did this armed robbery and shooting, they were wearing gloves apparently.
Yes, sir.
And we would not generally expect to have gloves, right?
That's correct.
Now, you said that there was no indication that either of these people bled.
That's correct.
And I say either of these people are the victims, right?
Yes, sir.
But you are aware, because you did check the report, right?
Yes, sir.
And did you actually speak to the Deputy McMurtry?
No, sir.
You just read his report?
Yes, sir.
Can I ask you this? I mentioned the one way we can get a statement. The other way, aside from the transcribed interview, which is verbatim, is where you, as an officer, detective, deputy, you write a summary,
Yes, sir.
okay, which is not verbatim, right?
Yes, sir.
And it's a memory aid, right?
It's a what, sir?
It's a memory aid. You would write it in your report so that you would get the highlights of what somebody told you,
Yes,
right?
sir. Yes, sir.
Okay? It doesn't certainly capture the question and the answer that you ask of a witness. Can we agree on that?
Yes, sir.
And so when Michael Keetley is giving you statements back in January of 2010, what you were relying on in February and March and June, all the way up to your retirement, was the summary that you gave him from when he was in the hospital
Yes, sir.
with injuries that you cannot recall,
No, sir.
with a presentation that you cannot tell, right?
What do you mean by presentation?
Okay? Was he bandaged up anywhere?
Yes, he was.
Where was he bandaged?
I remember one bandage being on the stomach area.
Okay? What about his hands?
I didn't see any bandages on the hands. I
tell-
remember seeing the bandages.
Okay, that's what I want to check. Are you telling this jury there were no bandages on his hands, or are you telling this jury that you do not recall?
I don't recall.
All right, so that tells me that his hand or hands could have been bandaged, but you would not recall that,
That's
right?
correct.
You could recall that if you wrote that down on your report, right?
Yes, sir.
And you did not write down on your report.
That's
Is that
correct.
right?
Yes, sir.
The I think we've established you don't recall when he got out of the hospital, right?
No, that's correct.
Where did he go live?
I don't know that.
Okay, where was he living before?
I don't know that.
Was he living on his own?
I don't know that.
As a result of being released, did he have to go live with anybody?
I don't know that.
Did he have to be taken care of in any way?
I don't know that.
You said that he called you 3 or 4 times.
That's correct.
When was the first call that he made?
I don't know how long after the initial interview these calls were made.
Okay. When was the first call made?
I don't recall.
When was the second call
I
made?
don't recall.
Do you recall any date of any phone call that he made?
No, sir.
And the fact is, sir, when he called you, he was what we would call a concerned or motivated victim, right?
Yes, sir.
He wanted you to catch the guy who did this.
Oh, yes, sir.
And you would want to catch the guy who did this, right?
Yes, sir.
We've known each other for years. You would want that, right?
Yes, sir.
Absolutely. In fact, when you leave this department in June of 2010, you're going to pass that off to another detective, right?
It was given to another detective, yes.
What's his name or her name?
Jason Himmel?
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 Okay. Is he still with the agency?
I believe so.
Okay. And when you gave the investigation to Himmel, was Detective Himmel briefed on what you knew?
I didn't brief him. I was already gone when he was assigned the case, already retired.
Did you brief anybody before you left?
No, sir.
Was it just a file on the table that someone would pick up?
It was a file assigned to another detective, yes.
Did you tell Michael Keetley you were leaving the agency?
No, sir.
Did you tell him someone else was going to have to take on this case?
No, sir.
You did not document a single phone call that you and Michael Keetley had.
No, sir.
How many times did you call Michael Keetley?
I didn't.
Okay. So can I make sure that we know that what you are in this case is the lead detective?
That's correct.
And lead detective is a very standard terminology in the Hillsborough County Sheriff's Office, right?
Yes, sir.
As far as you know. Lead detective is the man who is in charge, yes?
Yes, sir.
And now that doesn't mean it's only your way, right?
Right.
There are other detectives. You were in the major crimes, or what they call it, violent crimes at that time?
Criminal Investigations Robbery Unit.
Okay. They change all the time over the years. Whatever the name of it was at that time, robberies and crimes of violence such as this were what you were doing.
Yes.
And you were certainly not the only detective in Hillsborough County to do that, right?
That's correct.
At that point in time in 2010, was it you had a unit working together?
Yes.
8, 9, 10, I may have the number.
I think it was 7 to 8 people at the
All
time.
right. So you, Detective Nolan, get a case. Nothing's going to prevent you from going to Detective Himmel, Detective Jones, or whoever to do what we call conference or discuss a case, right?
Okay, what was the question again?
Yeah, let me put it to you better. You have the ability, if you want, to go to any other detective in your unit and say, hey, got this case. Can I talk to you about it? Can I get some ideas how to further investigate?
Yes, I have the ability to do that, yes, sir.
Right. And in several cases, maybe not one of this size, several cases, there will actually be someone who is assigned as a second or an assist, right? Do they still do that
Not
back in
usually.
2010?
Not usually, I was
Okay.
never assigned a second person.
Well, let me put it to you this way. When you have things that can be done in an investigation, it doesn't necessarily always have to be done by you. Is
That's
that
correct,
right?
that's correct,
For example, taking something to FDLE, right?
correct.
All right. What happens is when you get evidence in cases, evidence can be sent to FDLE, right?
That's correct.
Sometimes they've got a fingerprint unit over there, but Hillsborough County Sheriff has their own, right?
That's correct.
And so typically you're not going to send anything over to FDLE related to fingerprints, right?
That's correct.
But internally, the Hillsborough County Sheriff's Office has nothing at all with DNA, right?
That's correct.
All right. That has to be shipped out to FDLE.
Correct.
Let me talk to you about this idea here. When we talk about FDLE, a detective may be running evidence out in other cases and can take yours on a run, right?
That's correct.
Okay, that would be what we call an assist, right?
Yes, sir.
Also, when you're interviewing people, oftentimes you will have an assist or a second with you, right?
Yes, sir.
Particularly or especially with a suspect, right?
That's right.
And that is so that when you're asking questions and you're talking to somebody, it's potential that you miss something, right?
Yes, sir.
That the other detective can say, hey, can we go outside? I think you need to ask 1, 2, 3, right?
Yes, sir.
All right. So an assist can be very valuable, right?
Yes, sir.
An assist may not be in charge, but an assist or a seconding detective can certainly say, hey, I think we need to do this particular investigation, right?
Yes, sir.
For example, they could say, if you had an assist or a second with you at the hospital, hey, I think we need to check to see his medical condition, right?
Yes, possible. Yes, sir.
Right. Or an assist could say, hey, this guy looks pretty beaten up. Let's make sure we get this recorded, right?
Yes, sir.
Have you ever had a victim change or adjust their story?
Yes, sir.
Happens a lot,
Yes,
right?
sir.
Have you ever had a victim call up and say, have you found the guy?
Yes, sir.
Happens a lot,
Yes, sir.
right?
Yes, sir.
There was nothing unusual about what Michael Keetley did in calling you, right?
No, sir.
And in fact, those are the kind of victims you want to deal with because they're communicating with you.
Yes.
Okay, isn't it your experience that sometimes victims or witnesses will not cooperate
Yes,
with
sir.
police, right?
That's right.
You have a motivated, cooperative victim in Michael Keetley, right?
Yes, sir.
All right. So let me also make clear. You said today, and this is not insignificant, that Michael Keetley said the word on the street is. I'm going to talk about what the word on the street is in
Yes,
just a
sir.
second. He called you up and said, I'm hearing things, right?
Yes, sir.
I may be paraphrasing.
Yes,
Okay?
sir.
I'm hearing things, right?
Yes, sir.
And you know what I'm hearing? I'm hearing it was Hispanic people that did this, right?
Yes, sir.
Okay? He did not say, I'm changing what I said. It's no longer black, it's Hispanic.
That's
He
correct.
did not change, right?
That's correct.
Okay? Now, you were concerned with this idea of word on the street, right?
Yes, sir.
And there's a good reason for that,
Yes.
right?
Yes, sir.
What is that reason?
Because of the description he gave me initially, it's black males, and now he's telling me it's Hispanic males or Mexican males.
Now, let me be particular on this. He did not tell you it was Mexican males, did he?
Yes, sir.
He told you it was Hispanic males.
I believe it was Mexican males.
He told you it was Hispanic, not Mexican.
Mexican males.
Okay? Have you testified about this before?
Yes, sir.
Okay. You want me to show your previous testimony where you testified that it was Hispanic? I can do that.
Objection, Your Honor.
Legal basis.
Judge, improper impeachment.
Sustained.
Approach the witness. to refer to previous hearing testimony. You know what? I may have part of deposition testimony. This is your previous testimony, okay?
May we
Forward
approach?
to the date. Approach. Going to refer to prior testimony you gave on February 6th of 2020. Do you see that date here?
This is a deposition.
It is. I just made it bigger for you. You see that?
Yes.
Okay. This is not your deposition. Okay.
All right, I understand.
Okay. All right. We're going to talk about that.
Your Honor, may we approach? I apologize.
All right, so let me try to do it this way with you, Detective, okay? So you testified at a deposition, right?
Yes, sir.
And there was another time where you testified, right?
Yes, sir.
And you would agree with me that you vary between Hispanic or Hispanic and Mexican, right?
Yes.
Okay? So when I don't want the jury to be left with this impression today that Michael Keetley said it was Mexican.
I remember Mexican, yes, sir.
Okay. But you also remember Hispanic, right?
I don't remember that.
You're familiar with the Ruskin area, Waimama, Old
Oh,
Sun
yes,
City,
sir.
right?
Yes, sir.
There's a heavy Hispanic population there, right?
Yes, sir.
Were you aware that Michael Keetley had a regular route with his ice cream truck?
Yes, sir.
Okay. You remember the color of the ice cream truck?
Purple?
Okay. Yeah. You win. You look at me like you're looking for confirmation. I'll give you that. Right? So, yeah, a purple ice cream truck. You remember his route?
I think that day he was going to do the Old Sun City route and then go into the Manatee County.
Right, because he would not, because Ruskin, Waimama, Old Sun City Center, that's very close to Manatee, right?
Yes, sir.
Southernmost part of the county?
Old Sun City is, yes, sir.
Yeah, right. And so he would run routes through Manatee, Palmetto, right?
Yes, sir, I guess so.
And also Ruskin, Waimama.
Yes, sir.
Okay. You're familiar with the streets in Ruskin or not?
Some of them, they've changed a lot.
Right? But generally speaking, you had to be very familiar when you were running deputy patrol with the roads and the streets in your district and your zones, right?
Yes.
And taking it from you that Ruskin was maybe either not one of your regular zones when you were on the road, or it could have been a whole long time ago, right?
It was.
Okay. And people, actually, roads have grown, right?
Yes, sir.
And, Brandon used to be a cow pasture, right? So, as far as it relates to this case, you agree with me that you did not look into whether this was a dark-complected Mexican or Hispanic person.
No, sir.
You did not really look into whether it was a black person, right?
I had no suspects.
Well, that's kind of where I was going, afraid. Unfortunately, you have just eyes, right?
Yes, sir.
And medium complexion,
Yes, sir.
right? Nothing about nose piercings, or I don't think I've seen a tattoo on the nose or anything like that. No, nothing with eye piercings, eyebrow piercing, nose piercings, anything like that.
No, sir.
All right. Now you do have a white car, right?
Yes, sir. Beige car.
White beige, Buick Century, something like that.
Yes, sir.
2 donut tires, right?
Yes, sir.
Now you know what donut tires are, right?
They're spare tires. Yes, sir.
They don't run very long.
30 miles.
30 miles, if that, right? And so I think at some point in time you found a car that may have matched.
Yes.
Okay, had the dark tint, had the thing, but it did not have the donut tires.
Did not have dark tinted windows either.
Okay, did not have the dark tinted windows either. But tint can be removed, right?
I guess so. Yes, sir.
Sure. And of course, donut tires can and should be replaced, or at some point in time they'll replace themselves by running out, right?
That's correct.
All right. So you did not run the tag on that car, right?
Yes, sir.
You did?
Yes, sir.
And who did that come back to?
To a Hispanic male or a
Okay.
Mexican male.
And did you investigate that person, his whereabouts on that day?
I know his whereabouts. Yes, sir.
Okay,
He
on
was
that
in-
day.
He was in the hill on the day of the robbery.
Yes.
I don't know about the day of the robbery. When I ran the tag, he was somewhere incarcerated.
So he's in jail. And what day did you run that tag?
I don't remember.
Well, it had to be sometime before June.
Oh, yes, sir.
Okay, so we've got January 25 when you're a part of this case, and we've got somewhere around June when you leave the agency. Can you give me a ballpark where it would be between June and January? Should you not have documented that in your report?
I did. I don't remember I don't think I documented the date, but I remember documenting the tag number who the tag came back to.
All right, so I kind of left off on this idea of what Michael Keetley told you, because it's really important. He told you, as far as you recall, in that one interview in the hospital, that's the only time you saw him face to face, right?
That's correct.
In that one time face to face, he told you it was black males, medium complexion, right?
Yes, sir.
When he calls you on a date that you do not know, and he is saying the word on the street is this,
Yes.
right?
Yes.
He is not telling you, I'm changing my story.
That's correct.
He is telling you, as far as you know, it's still 3 black males, right?
2 black males and a female.
Thank you. Right. He has not changed his story.
That's correct.
Okay? I'm getting word on the street that it was something else, right?
Yes, sir.
And your concern, part of that is going to be for what we call contamination,
That's correct.
right? You're familiar with the idea of contamination,
Yes.
true? Contamination is where somebody gets information from another source, right?
Yes.
Okay? If it's a trusted source, your wife tells you something, you're going to naturally believe her because it's a trusted source, right?
That's right.
But in that sense, she has now contaminated your specific knowledge of a matter, right?
Yes, sir.
And so that's what you're telling him, right?
I'm telling you yes.
Right. Because you want your investigation, such as it is, and I mean that in the limited aspects that you have been able to do, you want your investigation to have integrity. Can we agree on that?
Yes.
And if we have word on the street contaminating what Michael Keetley knows, you may contaminate, or Michael Keetley may contaminate himself as a witness, right?
Yes, yes, sir.
The ability to articulate what's going on,
Yes.
right?
Yes, sir.
So when you're telling him about the word on the street, you're telling him, don't get that in your head, right?
I didn't tell him that way, no, sir.
Well, but that's the message, right?
Yes.
What's the message
The
then?
message that I told him that you're hurting this case. You could hurt this case by giving me different descriptions and different descriptions of the suspects.
Well, how is he hurting the case if he's telling you word on the street is that people are saying something different than what I saw?
Because he's giving a description of black males and 2 black males and a black female.
Right, but he's hearing word on the street of something different, right?
Yes.
And so you can try to investigate that, right?
I could try, yes.
Right. And so the questions were phrased to you by Ms. Doherty to suggest, did he give you this? Did he give you this? Did you ask him? Did you record these calls?
No, sir. I did not record them.
Tell me the name of one person that he told you about.
That's correct.
You cannot.
I
can you?
cannot do it.
Whether it be a street name, a nickname, Christian birth name, anything,
Yes.
right?
Yes.
And he called and said, look in this area, right? But he was not always able to give you specifics,
That's correct.
right?
Yes, sir.
Okay? He gave you license tags? You remember that?
You gave me a license tag?
Right? You remember that?
No, sir.
Okay? Are you saying it did not happen or you do not recall?
I don't recall.
Okay, I got it. And that's because you did not document it, right?
If they gave me a license plate, I would have documented it. Yes, sir.
Okay. All right. So are you saying it did not happen or did you maybe get it and fail to document it?
I don't remember him giving me a license plate.
Okay. How long were these calls in length?
2 or 3 minutes at the most, maybe 3.
Okay. Did he ever leave you any voice messages?
If he did, I don't recall.
I know, because it could be hard to find folks like you going out on the street, right?
Yes.
You're not always at your desk.
That's correct.
And even in 2010, I think the iPhone was new and smartphones aren't what they were today.
I guess, yes, sir.
Were you still carrying a pager? Or you
Yes,
got-
sir, I was.
Okay, so you're still carrying a pager. So it's not easy to get to you, perhaps, right?
That's correct.
Because your job, while there is desk work involved, is primarily being out responding to scenes, right?
That's right.
You did go to the scene on one occasion, right?
Yes, sir.
What date was that? What date was that you went out to the scene?
I don't remember the date.
What time of day was it?
Daytime because I was working day shift.
Okay. What time was this incident? What time was Michael Keetley shot?
I have to look at the report to find.
Sure. Take a look at it yourself, and when you're done, please look up at me, and we'll see if you're refreshed.
sorry, I got 164 pages here I'm looking through here.
Of that 164 pages, that's not primarily you who wrote it.
No, sir.
I'm about to say. We don't.
I'm looking for the original report.
Original report that he's looking for to expedite this if he can't find it? I was asking if anyone, he said he was looking for the original report in 600 and some pages. I'm just asking everybody has the original report that can be provided to him to expedite.
Yeah. Yes. Sorry, Ms. Doherty. May I approach?
You may.
Okay. All right. This may help you.
I had this is my report. I'm looking for the original report written by the deputies on what time this occurred.
Table that for just a moment. We'll come back, so we're not here through dinner. I'll make a note to ask that question again. Let me talk to you about this idea that when you went to the scene, we'll get there in a second. You've gone during the daytime shift, right?
Yes.
Was that still 6 to 6 or 7 to 7 or 8 to 5? What was it?
8 to 4:30.
8 to 4:30. Why'd you go to the scene?
Just to view it and just to view the scene.
Okay. It was kind of a residential area where he was shot.
Yes.
Okay, so there were multiple houses there.
There's houses there.
Yeah. Did you? By the way, you know what a neighborhood survey is, right?
Yes, sir.
Do you know whether a neighborhood survey was done on January 23rd, 2010 by then Deputy McMurtry or anybody else?
Yes.
Okay. Now, a neighborhood survey is where police will knock on doors and they will ask, hey, were you home? Did you notice anything, right?
That's correct.
And what we've added over the years with technology, do you have any cameras at home, Ring doorbells or anything? I don't know if Ring was a thing back then, but do you have any camera or surveillance that we may be able to look at?
Yes,
right?
yes.
Now, oftentimes, a neighborhood survey is to be done to be thorough and complete. So
Yes.
to not miss a potential lead that may not be obvious. You know what I mean? by that,
Yes.
Right? Because sometimes people are home, they think they hear something, nobody ever asks them, and we lose witness testimony, right?
Yes.
What was the result of the neighborhood survey done by Mr. McMurtry, Deputy McMurtry? Do you know? Or anybody else in law enforcement, if he was not the actual one?
There were a lot of surveys done that nobody saw, heard shots, but did not see anything.
Okay. All right. Now, sometimes neighborhood surveys occur when you go back and ask again, right?
Yes.
Now, when you went back to the scene, did you re-engage with a neighborhood survey?
No, sir.
Why not?
Because nobody saw anything other than hearing shots.
Well, how many people, okay, let me put it this way, do sometimes people hear shots and want to stay out of investigations?
That's a possibility, yes, sir.
In fact, it's happened to you before where people hear or see things and they say no, right?
Yes.
And sometimes you have to go back and you have to ask them again, right?
Sometimes, yes, sir.
And sometimes those people who originally said I did not see anything actually do see something, right?
Sometimes.
Right. So there's a value about going back and asking this question again.
Yes.
All right? But you did not do that.
I did not.
Okay? Did you ask anybody else?
No, sir.
Okay? So I know we're maybe still digging with the time. Did you go out to that scene at the time of the event, or did you go out at that scene just because you were on duty?
Yes, just to view the scene. I was not there at the initial
I asked
robbery.
that. I'm sorry, I'm interrupting, Detective. I asked that question back. Sometimes people go out to the scene at the time the event takes place.
Correct.
Okay, and that's the actual time, right?
Yes, sir.
Sometimes people will go follow up to a scene at the same day or time of day when it occurred, right?
Correct.
Something occurs Monday at 4 o'clock, you're going to go out Tuesday at 4 o'clock to try to replicate conditions, right?
Yes, sir.
You did not do that while going out. You just went out during your time, right?
Right.
And obviously, people in the neighborhood, they may work, right?
Yes, sir.
They may be gone, right?
Yes, sir.
So sometimes you can send, and deputies are sent out during the evening shift to do another neighborhood survey. Hey, did you hear anything? Right?
It's possible, yes, sir.
Okay. Wasn't done, right?
Correct.
If this had been a Hispanic man, you would have wanted to make the arrest, right?
Yes, sir.
White, black, Asian, whatever, you would have wanted to have made that arrest, right?
Yes. Yes.
And you, as a detective, have to sift through information. Can we agree with me on this?
Yes.
That sometimes we have facts that are important, right?
Yes.
Sometimes we have facts that are not important, right?
Yes.
They may be interesting, but they're not important to find out what's going on, right?
Yes.
Okay? And you, at this point in time, have at least Michael Keetley telling you something, and Michael Keetley telling you, I have more information that is different from what I told you, right?
That's correct.
Okay? And you told him to ignore it.
I didn't tell him, no, sir, I did not tell him that.
Okay? Did you follow up on it?
I had nothing to follow up on. No addresses or names to follow up on.
Let me ask you this. When we say you had nothing to follow up on, there was a blood or blood-like substance outside of the van, right?
Yes.
Okay, there was a shell casing, right?
Yes.
And you said you processed that for prints, right?
It was processed for prints.
That blood was swabbed, right?
Yes.
And what happens is there's a swab. I know the name, but I always pronounce it wrong. There's a swab with a substance that can determine whether that red substance is in fact blood, right?
Yes.
And if that substance can in fact lead to a DNA profile, right?
Yes.
And if in fact that DNA profile can be something that's viable and can be comparable to something, right?
Correct.
Now I get what we're assuming, okay? That these people, no indication that they bled, right?
Yes.
We don't know that they did not bleed, right?
We don't know that.
Right, because I mean, he's just getting his stuff, all $12 taken from him, and he's shot multiple times, right?
Yes.
Bleeding heavily,
Yes.
right? He doesn't have the time to say, am I the only one bleeding here, does he?
I don't guess so. No,
Guess
sir.
not, right? So what we have there is a substance that can be taken to biology and serology at FTLE, right?
That's correct.
Can we develop a DNA profile, right?
Yes.
Can we compare it to something, right?
Yes.
And you know what the DNA database is, right?
Yes.
The DNA database is a collection over time of people giving samples, right?
Yes.
And there is a way that if a sample is viable, that can be run through the system.
That's
right?
correct.
To see if there's a match.
Yes, sir.
Okay? And that could be a terrific investigative lead, right?
Right.
Could have been a black male, right?
Could have been.
Could have been a Hispanic male, right?
Yes.
Could have been a Mexican male.
Yes.
Okay? It could have been someone who did this to Michael Keetley,
That's a possibility, yes.
right? You did not take that to FBLE, did you?
No, sir.
You did not request that to be done, right?
That's correct.
That is a lead that you could have done, sir. Can we agree on that? And if not you, any of the detectives behind you. That could have been done, right?
It could have been done.
And it was not done.
It was not done.
I have nothing further.
Just briefly. Sir, you did know that Mr. Keetley had been shot more than one time. Is that correct?
Jack leading.
Yeah, rephrase.
Were you aware of that he had been injured? Is that correct?
That's correct.
Where were you interviewing him?
Yes.
Did he indicate to those other first responding deputies as to what caused his injuries?
That he was injured?
Yes.
Yes.
Okay. And when you were going back to that interview of Mr. Keetley on January 26th of 2010, when you said he was coherent, was there any time when you were talking to him that he seemed confused or not understand what was going on?
No, ma'am.
Jack calls for a medical conclusion and is speculative.
I'll rule out loud.
Did he, you can answer the question.
No, ma'am.
Okay. Was he able to adequately or appropriately respond to your questions?
Yes, ma'am.
Did he ever slur his words?
No, ma'am.
Did he ever sound like he nonsensical
No, ma'am.
in response to one of your questions?
No, ma'am.
Was he able to provide you with consistent statements that he did to the first responders back on January 23rd of 2010?
Yes, ma'am.
And if there was any time or any point of time where he felt like he was not talking, did he ever indicate that to you?
No, ma'am.
Okay. So he did not have any issue providing you with an interview on January 26th of 2010?
Object, leading, counsel testifying.
Rephrase.
Was there any, did he ever indicate to you during that interview that he wanted to stop the interview?
No, ma'am.
And after that interview, did you use the basis of that to put out that alert that you talked about?
I put the alert out before I interviewed him, the written alert.
Okay.
Yes, ma'am.
And where did you get the description information for that alert?
From the original report.
Okay. And did you go over those descriptions with him again during your January 26, 2010 interview?
Yes, ma'am.
And when he is telling you the descriptions of black male, did he ever nuance it to you to indicate that it was a dark or light-skinned Hispanic black male?
No, ma'am.
Was the only description that he provided concerning race was black male?
Correct.
I don't have anything further, Judge.
May this witness be released or subject to recall by the state?
He can be released, Judge.
Released or subject to recall?
Subject to recall, he does not need to hang around today.
All right, you may step down, but there's a possibility to be recalled, so thank you very much.
Yes, sir.
And ladies and gentlemen, we're going to go ahead and take our afternoon break, so I'll get you out of here while we're packing up, the witnesses packing up. Please do not discuss this case amongst yourselves or with anyone else. Please do not do any research related to the case. We'll take about a 20-minute break, and we'll see you back when you are ready. All rise for the jury. Jury has exited. Everyone may be seated. I'm not sure if we're going to be there yet with any of the remaining witnesses, but I did find the instruction. Actually, my JA printed the instruction on prior witness testimony that was presented. So if you all want to take a look at it, my suggestion is that I read that as well as 2.2 edited, if in fact edited is appropriate for any of the things that you're going to play. All right. All right, we'll go ahead and take a break, and then we'll come back and we'll ask the state to call their next witness. The plan is to go up to, I told him I'd try to get him out of here before 4:30, so it's 3:11. If we come back at 3:30, you know, an hour and a half is 5 o'clock, so an hour and 15 minutes or so.
You have 3 witnesses we have to get on today.
We're sending him to
The expression.
Have to, as in, if the cross of each of them is 2 hours long, we're still going to get them on today? I'm not suggesting it. That's a hypothetical. I mean, if it keeps us here until 2 a.m., we have to get them on.
No, we'll talk to one of them that traveled from Polk and see. If they
Yeah,
can-
I mean, I just don't know. As I sit here, I said we'd try, but I mean, there's a difference in going till 5:30 and going till 8 o'clock to get 3 witnesses on.
I know,
Just don't
Judge.
how- I mean, they're short from our stance. I don't know how long defense is going to be, but they're short witnesses for the state.
And I can't really limit them, unless there's objections that are.
No, I know,
If
Judge.
they're getting into non-relevant, I can, rule on objections, but
And Judge, we just need to know why today? I mean, one's from Polk County. I travel Polk County 3 times a week.
He's retired law enforcement, so we would like to, if he traveled all the way here.
let's see where we're at 5 o'clock. So I don't mind keeping them for that time, but I told them I'd try, and if there's someone we're almost done with, then absolutely we'll go past 5. I'm just saying, I'm not going to make them go until 6, 7, 8 o'clock tonight.
No, I understand.
All right. Is the jury ready? Is the defense ready?
Yes, Your Honor.
Let's get the jury.
All rise, jury, entering courtroom.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Let me just ask briefly, during the break, was anybody exposed to anything about this case, or did anybody discuss anything about this case? By show of hands, let the record reflect there are no hands. Again, thank you all very much, and I'll ask the state to please call their next witness.
Stand up, call Brianne Gregory.
Brianne Gregory. I found it. Miss Gregory, good afternoon and welcome. If you'll come forward to be sworn as a witness wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. If you'll follow the bailiff down to the ramp that leads up to the witness chair, please watch your step. I believe there's some cords. When you get to that seat, go ahead, have a seat, make yourself comfortable. The microphone in front of you is fully adjustable. You may proceed.
Will you please state your name?
Brianne Gregory.
Spell your last name for me, please.
Gregory.
Miss Gregory, I'm going to take you back to 2010. What were you doing for work back then?
Bartending
Where were you working?
at a golf course.
All right. Was there a time that you went to a different bar, Shenanigans?
Yes.
Okay. In 2010?
Yes.
Who'd you go there with?
My friend April Dosher.
Did you meet anybody there?
Yes.
Bunch of people, fair.
Yeah.
Did you meet Michael Keetley there?
Yes.
Was that the first time you met him?
Yes.
All right. So tell me about this interaction.
We just sat there and they were friends, and he described what had happened to him when he was robbed.
Okay, so let's back up a little bit. You guys are sitting where?
At the bar.
Where are you all sitting next to each other?
He was sitting on this side, like on the corner, and then it was her, and then it was me.
When you're speaking to your friend and Mr. Keetley, had you spoken to him before at all?
No.
First time you're meeting him?
Yes.
All right. You said that he was telling you about being robbed.
Yes.
What did you learn that day?
That he was robbed by 3 people when he was delivering ice cream for a small amount of money.
Is that the first time you'd heard about all of that?
I had heard about it through the news.
Okay. First time you'd heard about it from Mr. Keetley, then?
Yes.
Did you have an opportunity to meet him a second time?
Yes.
How long after the first time that you met him was it the second time that you met him?
Probably 2 weeks, maybe.
So tell me about that interaction.
We just ran into each other in passing at the same bar, and he asked if I knew anybody named Creeper.
Did that name sound familiar to you?
No.
Now, I want to kind of jump back to that first interaction. You said that it was on an ice cream truck.
Yes.
And then what other information did he give you during that first interaction?
That there was a girl and 2 guys.
Were you given any sort of description about race?
They were Mexican.
Is that told to you by who?
Him.
Him being who? Give me
Michael
names.
Keetley.
Okay. So now let's jump fast forward to this second interaction. Creeper. What's the context that that's given to you?
That he was involved or had something to do with him being robbed.
Do you remember the exact words that Mr. Keetley used to you when he's speaking to you in the bar that second time talking about Creeper?
Do you know anyone named Creeper?
Those are the exact words.
Mm-hmm.
What's
As
your
far as
answer?
I know.
Okay. What's
No.
your answer?
No.
Any follow-up to that conversation on that day at the bar between you and Mr. Keetley?
No.
Are those the only 2 times that you saw Mr. Keetley?
No.
Where'd you see him again?
At a party.
Where was that?
Like the address or
Basic area.
Ruskin.
What day was it?
Halloween?
October 31st?
Yes.
What year?
2010.
Same year that you'd spoken to him before.
Yes.
Who all's at this party?
A lot of people.
Friends of yours?
Mm-hmm.
Do you see Mr. Keetley at the party?
Yes.
Did you go to the party with him?
No.
Run into him there?
Yes.
Do you all take a picture?
Yes.
Are you all dressed in costumes?
Yes.
What were you dressed up as?
A mummy.
Say it again.
A mummy.
All right. And what was Mr. Keetley dressed as?
A cop.
Judge, I'm showing defense what's been previously marked as State's Exhibit 98 for any objections. May I approach the witness?
You may.
Showing you out of view of the jury what's been pre-marked as State's Exhibit 98. Do you recognize this?
Yes.
Have you seen this photograph before?
Yes.
Does this photograph fairly and accurately represent the picture you all took on October 31st, 2010?
Yes.
All right, this time I'd ask to move into evidence what's been pre-marked as State's Exhibit 98 as State's Exhibit 98.
We did it.
Permission to publish.
You may publish.
Ms. Gregory, there's a screen behind you and to the left. What are we looking at here?
A picture of me and my sister and a guy named Jonathan and Michael Keetley.
All right, so who's Jonathan?
The guy in the back with the hat.
Are you referring to, and I'll point to the top left-hand side of the photograph?
Yes.
In the middle, in the photograph, between you and your sister, who is that?
Michael Keetley.
You referred to the costume that he's wearing. Does this photograph depict the costume?
Yes.
Tell me what that costume was.
A cop.
Tell me what he's wearing that made you believe that it was a cop costume.
The word police.
Did he have other things, a gun belt, a gun, pants?
Yes.
So tell me about those.
He had camo pants on and boots and what I assumed was a fake gun, like part of the costume.
Was it in a gun belt or a holster?
Yeah.
Was all
It
of,
was on his like waist.
okay, all of that visible when you're seeing him walking around?
Yes.
Okay. May I have a moment, Your Honor?
Yes.
Do you see Michael Keetley in the courtroom?
Yes.
Would you point to him and tell me what he's wearing?
A gray beige cardigan and a white shirt.
Your Honor, please let the record reflect that the witness has identified the defendant.
Ready, Charles, over five.
I'll pass the witness.
Cross.
That's briefly, Your Honor.
Yes.
Good afternoon, Ms. Gregory. You previously testified that you had several interactions with Mr. Keetley.
Yes.
All of those interactions in combination, very brief,
Yes.
including the Halloween party as well.
Yes.
Do you remember how many people were at that Halloween party?
Probably 20 to 30.
20 to 30. Everyone's drinking, correct?
Mm-hmm.
Is that a yes?
Yes.
And everyone's in costume.
Yes.
And again, when you spoke with Mr. Keetley at the bar, he asked you if you knew someone named Creeper.
Yes.
Simple yes or no,
Yes.
and left it at that.
Yes.
May I have a moment?
Yes.
No further questions.
Redirect
No redirect. She may be released.
and released by the defense or subject to recall?
Subject to recall.
All right, you may step down. You don't need to wait outside, but you are subject to recall potentially.
Okay.
All right, thank you. I will ask the state to please call your next witness.
We would call Stacy Rogan.
Stacy Rogan. Ms. Rogan, good afternoon and welcome. If you'll come forward to be sworn as a witness. If you'll face me, that's perfect. If you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. Make yourself comfortable. That microphone in front of you is adjustable. You may proceed.
Good afternoon, Ms. Rogan.
Good afternoon.
Could you please state your first name and your last name and spell your last name, please?
Stacy Rogan, Rogan.
And do you know the defendant in this case, Michael Keetley?
I do.
Is the chair you need to
Yeah,
fix
it's
it
a
a little bit?
uncomfortable. I'm okay.
Okay. How is it that you know Michael Keetley?
I met him in Riverview.
Did you ultimately get in a romantic relationship with him?
I did.
Do you see him here in the courtroom today?
I do.
Can you please point to him and describe an article of clothing that he's wearing?
White shirt.
Please
and
let the
point.
record reflect that Ms. Rogan has identified the defendant, Michael Keetley. And do you recall approximately when you were in this relationship with Mr. Keetley?
2009.
And approximately how long did you date him for?
Probably anywhere from 6 to 9 months.
And was this a steady relationship or was it an on and off again relationship?
It was on and off.
And when you dated him in 2009, that was prior to any injury he sustained in January 2010. Is that correct?
Yes.
And what did you do for a living in 2009 when you dated Mr. Keetley?
Owned and operated an ice cream truck.
And what color was your ice cream truck?
Purple.
And what area did you work?
Riverview.
How long did you do that for? How long were you an ice cream truck driver?
About 20 years.
And what was the name of your business?
Ice cream chick.
Ice Cream Chick, like
Yes.
CHICK? In 2009, when you were dating Mr. Keetley, was he an ice cream truck driver?
Not when we first met.
What did he do when you first met him?
I don't think he was doing anything. He said he had been laid off from a job.
Do you recall where he was working previously?
Maybe an airline, like as an airline mechanic or something.
Okay, is that what he had told you? Mm-hmm. Is that correct? Is that a yes?
Yes, ma'am.
After you began dating him, did he soon thereafter become employed or get a job?
He started his own ice cream truck.
And how did he go about doing that?
He purchased a van, and I taught him what to do, and he started doing it.
And you taught him what to do because you had been doing that for many years before. Is that correct?
Yes, ma'am.
Do you recall when your relationship ended? I'm not asking for an exact date. I know this was many, many years ago. Do you remember what season it may have been in 2009 when your relationship ended?
The fall, like around October.
Of 2009?
Mm-hmm.
Is that a yes?
Yes, ma'am.
And did you maintain contact with the defendant once you and he broke up?
I don't believe that we talked in between that last time that we broke up until he had reached out after he was shot.
So there was no contact from the time you broke up until you said until he had got shot. So how did that contact happen?
He called from the hospital.
And do you recall, was that in January of 2010?
Yes.
And what did he tell you?
That he had been shot and he was in the hospital, and
Did he tell you anything other than the fact that he had been shot?
He told me that he explained to me what happened in his, his version of what happened. He said that somebody had tried to pull him over for ice cream. They had given him the brights, and he pulled over, and a light-skinned black female approached the truck, asked for soda. He turned around to tell her what he had in the truck, and then when he turned back around, there was 2 masked gunmen.
And you said they flicked their lights. What do you mean by that?
Like they're brights, they're hazard lights, or bright lights.
And is that a sign to
If
you
somebody's
as being...
motioning for you to pull over, somebody was behind you and they kept flicking the lights to get your attention.
Okay. Is that a common practice for individuals who want to get the attention of an ice cream truck driver to pull over? Is that something that you've had experience with?
I don't know if it's a common practice, but yes, it's happened to me before.
Okay. And so he proceeds to tell you that a black female had approached him and asked to purchase a soda.
Mm-hmm.
Is that a yes?
Yes.
And he told you that when he had turned back around to tell her what brands he had, there were 2 masked men?
Yes, ma'am.
Did he tell you what ethnicity or race they were?
Two black masked gunmen.
Did he provide you any other description other than that you've stated here today?
Mm-mm.
Is that a no?
No.
We just have to make sure you say yes or no out loud so that the court reporter can take everything down.
I'm working on it.
Did you know whether or not the defendant carried a firearm with him in his ice cream truck?
He had one on him that particular day. I don't know if he did every single time that he worked, but I know that he had one that day because he told me he had one.
What did he tell you about that?
That he had a gun in his back of his pants.
Was he able to utilize it that day?
No, I believe that by the time he went to pull it out, they had already started shooting at him.
Between that call in January of 2010 from the defendant to Thanksgiving of 2010, did you maintain or did you have any other further phone contact with the defendant?
Can you repeat those dates again?
Sure. So when he called you in January of 2010 when he was in the hospital to Thanksgiving of 2010, did you have phone contact?
Yes, ma'am.
Okay. Did you have any face-to-face contact with the defendant?
Just one time.
Do you recall approximately when that was?
No, I don't know the month or when it was.
Can you tell me about that contact? What happened and where it was?
It was in the Rivercrest subdivision. I don't remember the name of the street, but I had come to a full stop and he was at a house across the street and he walked straight towards my truck to talk to me.
You were in your ice cream truck?
Yes, ma'am.
Was this in the Riverview area?
Yes.
Were you working that day?
Yes.
And did you see where he being the defendant, had come from to approach your ice cream truck?
From a house across the street.
And what observations did you make, if anything, when he approached your truck?
None other than he just walked up normal to my truck.
Did he walk up normal and appear normal as the last time you had seen him when you broke up with him in 2009?
Yes, ma'am.
And did you engage in a conversation with the defendant?
We did.
Do you recall any specifics about that conversation?
I do not.
Do you know approximately how long that interaction lasted?
A few minutes, maybe.
And then did you leave or did he leave?
I'm assuming he walked back to the property that he had come from and I continued on my route.
Okay. You had previously stated that between January of 2010 and November of 2010
that there was some phone communication. Is that correct?
Yes.
Was there also text messaging?
I'm assuming so, yes.
What information would you and the defendant communicate about during this time frame?
I mean, at first he was just kind of calling to keep me updated about how he was feeling, you know, his health progress, I guess, and where he was at, and yeah, that's pretty much it.
Was he working at that time initially that you recall?
No.
Did you learn whether or not he had begun to work at some point?
Yes. I believe he started taking an ice cream truck back out again.
And did you learn that from your communication with him?
Yes.
Did he discuss with you anything else regarding the facts of his robbery? The robbery that he was the victim in?
Not really, other than that he was trying to find the people that did it to him.
Did he tell you what actions he took in order to try and find the people that committed the crime against him?
He was talking to a lot of people in those neighborhoods.
Did he talk to you at all about his feelings about law enforcement's investigation regarding that?
Yeah, he was very frustrated that they weren't listening to him, and yeah, he was very frustrated that they weren't listening to him. He felt that they weren't listening to him and they weren't doing anything about information, I guess, that he was getting.
Did he tell you that he was doing anything other than going out in the community and speaking to people?
Not that I recall.
Okay. Did he tell you any information about what he had in fact learned through his investigation?
He had told me to keep my eyes open for a Mexican guy with a tattoo that said Creeper.
Were you still working as an ice cream truck driver at that time?
I was.
Were you aware of anybody with the nickname Creeper or with someone that with a Creeper tattoo down their arm?
No.
And what did he tell you to do if you in fact came across this person with a Creeper tattoo down their arm?
He didn't necessarily tell me to do anything, just to keep my eyes open. I mean, let him know, keep my eyes open if I saw this person.
Did he tell you to contact law enforcement?
No, ma'am.
Did you make any statements to him regarding the fact that he was conducting his own investigation regarding this robbery?
I told him that I felt that he should just let the police take care of their job, and yeah, that's really all I told him, is that I felt like he needed to let the police handle it.
When he had told you that he was that he had learned that a Mexican man with a Creeper tattoo was down his arm, did he make any further statements regarding the black female and the two black males that he had originally identified to you as a suspect?
No.
Did you call him out on that at all?
No.
Do you recall approximately how long before Thanksgiving Day in 2010 he had asked you to look for this person with a Creeper tattoo down his arm?
I want to say a few months. It was probably a few months before that.
Did he make any statements to you regarding handling things himself or taking this investigation into his own hands?
Not those exact words, but he was actively looking for the people that had shot him.
Did he make any statements about thinking that he understands how people take things into their own hands?
Oh,
and matters
yes.
into their own hands. He understands why people do that.
Yes, 100%.
In November of 2010, do you recall a phone conversation with the defendant regarding a purchase he was going to make?
Yes, ma'am.
Can you tell me about that conversation?
He had called me to let me know that he was at the Publix nearby because he was purchasing a handgun.
Did he give you any information about what kind of handgun this was that he was purchasing?
No,
Did he make any statements to you about why he was purchasing this handgun?
because that handgun that he had wasn't comfortable in his hand anymore.
When you made observations of him from that in-person contact, that one in-person contact, did you notice anything unusual or deformed or any kind of abnormality about his hand or his hand use?
No, I didn't.
The day after the shooting, on Friday, the day after the Thanksgiving shooting, did you learn about that shooting?
Yes.
Did you contact law enforcement when you learned about the shooting that took place on Thanksgiving morning?
I went to law enforcement with whatever information I felt could be helpful.
And did you tell them the information that you have stated here today?
I did.
May I have a moment, Your Honor?
Yes.
Ms. Rogan, when I had questioned you about the one in-person contact that you had with Mr. Keetley, you said that he walked normal. And so I want to define that a little bit. When you saw him walk, did you see him walk with a limp?
Not that I recall.
And this is in 2010, after you saw him after the shooting in January of 2010. Is
Yes,
that correct?
ma'am. Yes.
Nothing further, Judge.
Good afternoon, Ms. Rogan.
Good afternoon.
You just testified that you and Mr. Keetley dated somewhere around the ballpark of 6 to 9 months, ending end of 2009. Is that correct?
Correct.
And I believe you used the phrase on and off again. We're all familiar, on and off, meaning not consistent, not stable, correct?
Correct.
And you only saw Mr. Keetley one time after he had been robbed and shot that January of 2010, correct?
Correct.
Any communications that you may have had besides that one time, and I'll get to that, would have been texts, emails, phone calls.
Texts and phone calls, yes.
You indicated that you heard Mr. Keetley was taking the ice cream truck back out at some point. Is that correct?
He told me that, yes.
He also told you that he hired someone to assist him.
Correct.
And during those conversations, again, I'm moving towards after you guys broke up finally, after Mr. Keetley had been shot and robbed. During those conversations, he told you people were coming up to him on the streets about information. Is that correct?
I believe it was more he was looking for information. He was going out seeking information.
So you don't recall that Mr. Keetley told you that people were coming to him with information, word on the street, essentially.
I mean, it's a matter of different words that we're using, but yes.
I'll rephrase that.
He was looking for information, he was getting information. People were coming forward and...
So, yes, people were coming to him, word on the street, essentially saying, hey, here, maybe this, maybe that. And at that point, that's when you learned of the name Creeper, specifically a tattoo on the arm, Creeper.
Yes.
For you to look out for that tattoo, correct?
Yes.
And you testified as well that there was a time on the phone that Mr. Keetley mentioned he was on his way to Publix to get a gun that would be more comfortable in his hands, correct?
Yes.
You never saw this, the firearm never followed up on that conversation.
No.
And the one time in which you did see Mr. Keetley after he had been shot was very brief, correct?
Correct.
You were driving the ice cream truck, therefore focusing, I know you stopped, but you're focusing on your route, right?
Correct.
Very brief interaction in which you're not really focusing on his abilities, correct?
I mean, I came to a full stop and he walked towards me. It's not.
Were you focusing on his abilities to maneuver?
I just watched him walk towards me.
Right, because that wasn't the focus, correct?
I suppose.
And you weren't watching him maneuver his hands. It's not like he was helping you out with something or holding anything.
No, not at all.
So you would not be able to testify to those injuries.
No, I didn't notice any injuries.
But you also wouldn't have been able to see any limitations at that point.
Yeah, I would assume.
And you mentioned that you spoke with detectives. I believe it was the Friday after the shooting. Is that correct?
The day after Thanksgiving.
Yes.
Yes, Friday.
In which you mentioned you brought forward whatever information you had.
Correct.
And several hours prior to this conversation with detectives, you were made aware of a text message that was circulating in the community about Mr. Keetley.
Several hours?
Yes.
I went to the police as soon as I learned about the text message.
If I may have a moment.
Yes.
Another question, thank you.
Redirect?
May I have a moment, Judge?
Yes. May she be released by the state?
She's released by the state judge.
Subject to recall or released by the defense?
Subject to recall.
All right, ma'am. You may step down. You are subject to recall. Does that mean you need to wait outside today? We'll notify you if you need to come back. Thank you. Absolutely.
State will call Ron Cashwell. Ronald Cashwell.
Cashwell, Ron Cashwell. Mr. Cashwell, good afternoon and welcome. You'll come forward to be sworn as a witness. Wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. When you get to that ramp, go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjusted. Let me know when you're ready.
Okay.
Proceed.
Would you state your name, please?
Ronald Cashwell.
And spell your last name for me.
Cashwell.
I want to take you back to November of 2010. Where did you work then?
Hillsborough County Sheriff's Office.
In what role and capacity?
I was a crime scene detective.
And as a crime scene detective, did you have specific responsibilities and duties that would essentially vary per scene that you're responding to?
Yes, ma'am.
All right, so just basically and kind of overall, give us what is a crime scene detective? What do you do?
We responded to major crime scenes where we were responsible for taking photographs, collecting evidence, processing evidence, aerial photographs, things of that nature.
In a typical scene such as the one we're going to talk about now, would there be more than one crime scene detective or crime scene investigator that responds?
Yes, ma'am.
Do each of you have kind of individual roles that you're going to fill in that job assignment on that scene?
On every scene, yes, it could be different.
In the case that originates at 604 Ocean Miss Court, was there a lead crime scene investigator?
When I arrived there, CSI Patel was the lead crime scene on that.
You assigned a different role than the lead crime scene investigator.
Yes, ma'am.
What was your role?
I originally responded to the Ocean Miss, the 604,
Yep.
and met with my supervisors, and they requested that I respond to a couple of other addresses on Ocean Miss and then another address.
Okay, so we're going to get to those in a few minutes, but fair to say you're not the lead investigator for this incident.
No, ma'am.
So when you arrived to 604 Ocean Mist, approximately what time is it?
Around 5 o'clock in the morning.
Starting to go from dark to light.
Correct.
Were you coming on as a day shift investigator?
Yes, ma'am.
Taking over for who would have been there initially as the night investigators?
Correct.
In that role, did you speak with detectives that were on scene?
Yes, ma'am.
Did you speak with other crime scene investigators that were on scene?
Yes, ma'am.
Were you essentially briefed on what had happened prior to your arrival?
Yes.
Were you given responsibilities at that point?
Yes, ma'am.
Okay, so now let's go into the different locations that you respond to.
Okay.
Where do you go first?
Well, I originally went to the 604 first, met with my supervisors,
And then do you respond to a second location?
and then I responded to two other locations on Ocean Mist.
Where's the first one you go to?
Was 612.
Why?
There was a vehicle there that was held by deputies that supposedly one of the victims had responded back to the scene, and so I was asked to go photograph and process that.
Now, as part of the briefing before you start your work, did you learn that there had been a victim that had left the scene and there was some information or evidence that may need to be collected?
Yes, ma'am.
Was that vehicle that you responded to part of what you had learned? Was that evidence?
Yes, ma'am.
When you respond to that vehicle, what do you do?
First on scene, would take photographs of the vehicle, and there was some EMS personnel there that pointed out there was some of the victim's clothing that had been left behind. So pretty much there I would have taken photographs, collected some evidence, and maybe some blood swabs.
Now, when you're conducting your work, do you have either a detective or a deputy that's with you?
Normally there would be one on scene, yes, ma'am.
Are you and that deputy or detective talking about what you're going to photograph and what you're going to collect?
Yes, ma'am.
Do you all work together to make decisions on, yes, this is something that may be relevant to the case?
No, yes, ma'am.
Do you also have the authority and the training to make some of those decisions on your own?
Yes, ma'am.
When you're taking photographs, is there a system for taking photographs to document where an item may be coming from?
It would depend on the scene, but normally you would take overall photographs, then intermediate, then close-ups, things like that.
When we're talking about this car that you responded to, so a second, we'll call it scene, do you take those overall, intermediate, and close-up photographs?
Yes, ma'am.
Showing defense what's been pre-marked as State's Exhibit 68, 68A, 69, 70A, 70B, 71, 72, 73, 74, and 75 for any objections.
No objection, Your Honor.
May I approach the witness? Mr. Cashwell, I'm showing you, and I'll read the exhibit numbers out in a moment. So if you'll just take a look at that stack of photographs, let me know if you recognize them. And are these photographs in the same or substantially same condition as the last time you viewed them?
Yes, ma'am.
Judge, at this time I'd ask to move into, and I can read all of the exhibit numbers into the record. Move into evidence what's been pre-marked as State's Exhibit 68, 68A, 69, 70A, 70B, 71, 72, 73, 74, and 75.
No objection?
No objection.
They'll be admitted.
And permission to publish.
You may publish.
All right, Mr. Cashwell, so we'll get to these photographs in just a second. So when you respond to this vehicle, what is the first thing that you're doing prior to taking your photographs?
I was meeting with my supervisor.
Do you then learn what may be of relevance to you?
Yes, ma'am.
Do you photograph the vehicle before anything's touched, moved, or disturbed?
The photographs that I took of this vehicle was exactly how I found it when I arrived.
After taking photographs, would you then go on to essentially a second stage of your processing or your investigation?
Yes, ma'am.
All right, so we'll get to that in a moment. Showing you what's been pre-marked as State's, or what is State's Exhibit 72. There's a screen up to your left. What are we looking at here?
That would be an interior view of the passenger front seat area of a Chevy Impala.
And then I'm going to show you State's Exhibit 71. Is this the Chevy Impala that we're talking about?
Yes, ma'am.
And the vehicle that we're seeing in State's Exhibit 71, is that the vehicle that you said was the first, we'll call it scene, you respond to?
Correct.
All right. Let's talk specifically about this front passenger seat here. Was there anything of note to you in your investigation?
Definitely the red substance and the cell phone on the front seat.
Would you consider this to be a overall or a mid-range photograph?
That'd be a mid-range.
Do you have closer photographs of the items that were taken from that seat and documenting that seat?
Yes, ma'am.
I'm showing you State's Exhibit 74. Do you recognize that photograph?
Yes, ma'am. That's a closer view of the same passenger front seat.
And when you were referring to the red substance earlier, is that to the bottom left-hand side of this photograph?
Right on the seat bottom itself, yes.
And then the back of the seat, was that something you also photographed but in a different photo?
Yes, ma'am.
As we're looking at this seat, is this exactly how you find it?
Yes, ma'am.
The location of that cell phone, exactly where you find it?
Yes, ma'am.
All right. State's Exhibit 73. And I'll turn it this way for reference. What are we looking at here?
That would be the same passenger front seat, but a view of the back of it.
And then State's Exhibit 75.
That was a picture close-up of the cell phone that was actually located on the same seat.
Same seat and same cell phone we were looking at in the earlier photographs?
Yes, ma'am.
All right. Are you updating detectives on what you're finding, what you're documenting, and what you may be collecting as evidence?
Yes, ma'am.
Are they then working with other detectives and providing this information to other detectives?
Yes, ma'am.
At this point, do you have other photographs you take outside of the vehicle before moving to a second scene?
Yes, ma'am.
Showing you 70B. What are we looking at here?
Now, this
particular photograph was taken at another location on Domino.
And how does this photograph and that location relate to the vehicle and then what we get into in just a second?
Originally, one of the victims had climbed over a fence located on Ocean Mist and actually had fallen down at this scene and was transported from the Domino Circle back to the Ocean Mist court where the Impala was.
Did you learn all that information from the detectives briefing you?
Yes, ma'am.
Now, knowing that information, did that make what we're looking at in State's Exhibit 70B relevant to you?
Yes.
What are we looking at in 70B?
That is the actual blood spot from the victim that actually laid on that concrete.
And how far is this from the fence you were talking about, approximately?
From the backyard fence, 100 yards maybe.
Okay. So let's talk about the scene where we've got the backyard fence. What's the address of that location?
That would be the 604 Ocean Mist. I mean, sorry, yeah, 604.
All right, and I'm going to jump a little bit ahead. Did you take aerial photographs as
Yes,
part
I
of your investigation as well?
Yes, ma'am,
Okay.
I did.
I'm going to show defense what's been pre-marked as 190B, 190D, 190E, 190A, and 190C for any objection. May I first witness?
You may.
Mr. Cashwell, as part of your investigation, did you take aerial photographs?
Yes, ma'am, I did.
Do you recognize those aerial photographs?
Yes, ma'am, I do.
And are they the same or substantially the same conditions the last time you saw these images?
Yes, ma'am.
Okay. Your Honor, at this time I'd ask to move into evidence what's been pre-marked as State's Exhibit 190B, 190D, 190E, 190A, and 190C.
No objection from the defense.
You'll be admitted.
All right, so we'll get to the aerials in just a moment. So when we're looking at the fence line, you say it's about 100 yards from where the vehicle was.
Yes, ma'am, approximately.
All right. How does that fence line compare to the house that we see in photographs not taken by you, but by Ms. Patel?
They should be the same backyard of 604.
All right. So in State's Exhibit 5A, we're looking at the front of 604?
Yes, ma'am.
So give me directions on where the fence line is in relation to this photograph.
It would be directly behind that house.
And then what would be the street that would be on the back side of this house?
Be Domino Circle.
We're standing on Ocean Mist looking at the house.
Yes, ma'am.
Domino would be the street behind it.
Yes, ma'am.
So the fence that you photographed is the fence that would be between the house on Ocean Mist and the house that would have been facing Domino.
Yes, ma'am.
All right, let's talk about that fence. Showing you State's Exhibit 69. It's a little dark in this photograph, so if you need to get up and point, you can. But where's the fence that we're looking at?
There's a retention pond that runs alongside of that property behind 604.
Let me stop you for a second. Would that be down the middle of this photograph right here?
Yes, ma'am.
Okay.
And there's a steel fencing located in that photograph. That's the actual fence from 604.
Would that be almost directly in the center of this photograph?
Yes, ma'am.
The metal fence that we're seeing here?
Correct.
Was there anything, before you get up close and actually see substance on there, was there anything regarding the fence that looked like it had been broken or damaged?
At that time, it had already been marked by Crime Scene Patel as evidence marker, and there was a section of the fencing that was pushed down with possible blood on it.
Showing you State's Exhibit 68. Where in this photograph do you see the marker?
On the very top of the fence, you'll see where the fence is pulled down. That was evidence marker 19.
Are you referring to the yellow square we see up there?
Yes, ma'am.
So what's an evidence marker?
We usually put those down to locate evidence for crime scene photographs.
Did you put that evidence marker down?
No, I did not.
someone else put it before you take this photograph?
Yes, ma'am.
All right. So when we're looking at this photograph, what are you looking to document here?
Just pretty much the location of it in reference to the two houses and the evidence marker number.
When you're standing and taking this photograph, are you in the backyard of 604 Ocean Mist, or are you outside of that backyard?
No, I'm in the backyard of the Domino court scene.
This would be looking at then the backside or the outside of the Ocean Mist fence.
Correct.
Okay.
Correct.
And I'm showing you State's Exhibit 68A. Is this a close-up?
Yes, ma'am.
And that evidence marker 19, is that the same evidence marker that you referred to from the last photograph?
Correct.
And then there's a substance or a discoloration on that fence. Do you see that?
Yes, ma'am.
What are we looking at there?
It's possible blood that was left on the fence as the one of the victims climbed over it.
After taking your photographs, and we're still going to say that Domino Drive, Ocean Mist Court area, after taking your photographs of both sides of that property, do you collect items of evidence?
I did.
And where do you collect those from?
The first items were from the 612 Ocean Mist court.
Okay, and what was from there?
Victim's clothing and some blood samples, possible blood samples.
Were the clothes of the victim you're referring to, did you have it labeled as Daniel Beltran's clothes?
Yes, ma'am.
And were those clothes associated with the individual who went over the fence and into the car?
Correct.
Was that information that was provided to you by law enforcement, by detectives?
Yes, ma'am.
Did that information help you understand why those clothes may be relevant?
Yes, ma'am.
When you're collecting those clothes, do you have procedures and methodologies that you're following to ensure those clothes are collected properly?
After they were pointed out to me, they were photographed, markered, and then were apply gloves and put them in a paper bag and seal them up.
Once that bag's sealed, do you put labels and tape and your initials on it?
Yes, ma'am.
What's the purpose of doing all of that?
It just identifies that I actually packaged it, I collected it, packaged it, and sealed it myself.
Do those items then get taken to another location to be formally impounded into evidence?
Yes, ma'am. They're taken to sometimes to our office and then to the evidence room.
Are there times when maybe something needs to be dried before it can be packaged?
If it's wet or bloody, it has to be dried first.
Okay. In this case, were the items that you impounded into evidence actually taken to evidence to impound and kept there?
Yes, ma'am.
When those items are packaged and put into evidence, are they given a unique label and tag number?
They have an evidence property number.
Does that occur to all items of evidence?
Yes, ma'am.
And is that a system for documenting what may be received?
Yes, ma'am.
Right. Okay, let's talk about November 25th. So same day, but actually later in the day. Do you respond to the medical examiner's office?
Yes, ma'am, I did.
And what's the purpose of a crime scene investigator going to the medical examiner's office?
I was requested to go there by one of the detectives, I think it might have been Hollis, requested I go there to photograph an autopsy.
Is that a typical procedure that the sheriff's office will do?
Yes, ma'am.
Do crime scene investigators attend autopsies?
Yes, ma'am.
While you're attending that autopsy, do you take photographs?
Yes, ma'am, I do.
Do you collect items of evidence?
Yes, ma'am.
Typically, it would be clothes.
Clothing or projectiles or blood samples, hair fibers.
A fair number of items can be collected at an
Yes, ma'am.
autopsy. Are the photographs taken by the crime scene investigator at an autopsy the same photographs that are taken by the medical examiner's office?
We take them at the same time, so a lot of those are duplicates.
But you all are using your own set of photographs?
Yes, ma'am.
Could you be taking photographs for a different purpose than potentially a medical examiner would be taking photographs?
Yes, ma'am.
Do you document what you're collecting
Yes.
and the photographs that you're taking?
Yes, ma'am.
So which autopsies did you attend on November 25th of 2010?
The deceased name was Sergio.
Pietron?
Yeah.
And how many autopsies did you attend on the 25th?
One on that day.
Was that the only autopsy you attended for this case?
No.
Was there a second autopsy?
Yes, ma'am.
And what was the date of that one?
The following day on the 26th.
Same procedures that you would have followed?
A little bit less because I believe an autopsy had been performed on him, and I went to do additional photographs the following day.
Would there be, in your experience, different procedures depending on if somebody was pronounced deceased at the scene compared to if they went to the hospital?
Yes, ma'am.
And did the autopsies you attend reflect some of that?
Somewhat. There, I mean, there was less photographs for me to take because they'd already done a lot of the autopsy.
All right. Let's talk about December 4th.
Okay.
Did you continue to do work regarding this investigation but at a different location on December 4th?
Yes, ma'am.
Did you respond to 4935 Bonita Drive?
Secondly, originally we responded to the district office where we all met around 8 o'clock in the morning, and then we went out to the search warrant. There was a lot of sheriff's personnel there.
Before you arrive on scene at Bonita Drive, are you briefed on why you all are going there?
Yes, ma'am.
What may be taking place?
While we were there, we were briefing on what we were going to be looking for and what the address was and how we were going to conduct the search out there.
Fair to say it's a large piece of property.
Yes, ma'am.
Were there multiple crime scene investigators who were responding to that property?
I responded with one other crime scene person and a few supervisors of mine.
Were you aware that that was not the first time that law enforcement, because of this investigation, had responded to that location?
That's correct.
So based on that, did you have knowledge going in as to what your role was going to be?
Yes, ma'am.
So despite it being December 4th, were you aware that there had already been investigations conducted after November 25th at that location?
Yes, ma'am.
What was your role and your responsibility on December 4th at the Bonita Drive address?
When we arrived, it was such a large scene, encompassed scene. There was already some detectives and sheriff's personnel out there, and we decided to split the property into two sections. One would have been on the Bonita scene. We would have split it down the middle, and crime scene Hager would have worked one half, and I would have worked the other. And they were primarily looking for dig sites, burn sites, projectiles, casings, things of that nature.
Okay. Was there any involvement by you in any sort of search or investigation inside of the home or homes located on that property?
I never went inside the home.
Yours was exclusively outside?
Strictly outside.
Okay, so when we're talking about December 4th, we're talking about a search on the exterior of any residence that may be on that property.
Correct.
When you're talking about splitting that property, are you talking about literally you're taking the ground that's outside of the house?
There was a road that went down the center, and we split it east and west.
And so you had which side, east or west?
Either west.
When you're conducting your search and your investigation, is that separate and apart from what crime scene investigator Hager would have been doing on the east side of that road?
Yes, ma'am. I never went on her side of the road.
And is there a reason for that?
I had pretty much been confined my search area to just primarily around the house itself.
When you're conducting your search, do you have patterns that you're following, procedures that you're following to ensure that you're not missing anything?
Some of the case detectives that were out there had already located a burn pit and a couple of possible dig sites, so that I pretty much responded immediately to those.
That focus your attention on those areas?
Yes, ma'am.
Limiting some of the other areas of the property?
I took some overall photographs of the other areas of the property, but mainly my work was considered that one area where the dig sites were.
Was part of your work aerial photographs at that location as well?
I did do aerial photographs on another day.
All right. And although another day, we're still talking about the same property?
Yes, ma'am.
And Judge, I'd move into evidence what's been pre-marked as 190B, 190D, 190E, 190A, and 190C, if I haven't done so already.
Some of them were, but there's some additional ones at this time. Is there any objection?
You want them again?
No, just for the additional ones, but I believe I already said no objection.
Okay, they'll be all these.
Okay, permission to publish.
You may publish.
Thank you. All right, Mr. Cashwell, I'm going to show you 190A. What are we looking at here?
That is an overall view, aerial view of the actual property at the 4935 Bonita Springs.
Now, you referred to a road earlier. Is this road what you're talking about down the middle of that property?
That would be the center, the road that divided the property into two halves.
And for cardinal directions, so east and west, which side, and you can use right and left in relation to this photograph, what side did you take for your portion of the investigation?
The right side or west side.
So when we're looking at the right side of the photograph, that is the west side of the property.
Correct.
So if we're going to go with cardinal directions, we would in fact flip this over.
The side that I had?
Yes.
Wow.
You want me to flip it back for you?
Yeah.
All right. So if we're looking at the right-hand side of the photograph,
Okay, now I
is
got
that the west side of the property?
Mine was the right side, the west
Okay.
side.
All right. So then where did you primarily focus your attention on that right side or west side of the property?
If you follow the road straight up from Bonita Springs up the driveway.
Let me stop you for a second. Would it be easier if you stood up and pointed?
Yeah.
Okay.
And also, there's a ruler up there that you made.
There's a yardstick right in front of you. There you go.
I don't know if I'm blocking anybody's view over there.
I'll let you know if you do.
Bonita Springs Road. This road is a 4935 split this property in half. And the area that I only looked at was primarily right here.
Now let me back you up for just a little bit. There's a clump of trees, and I'm going to point to it on here, that seem to be circling something. What are those trees circling?
This is circling the actual residence of 2935.
So when you're talking about searching around the property, are you inside that tree line or are you outside that tree
I
line?
actually took some photographs, and we're looking at one big site inside the tree line or fence line, but most of them were down in this area.
And how could you tell it was a dig site or a burn site? What indicates that to you?
The information relayed to me by the detectives when they were out there was they discovered, usually when
You can sit down if you want. Sorry, didn't mean to make you stand.
we actually dug up a dead cow at one of the sites, and usually what happens is when a cow decomposes, the soil will settle. So that was obviously one of the sites we would hit. And then the other one appeared as a fresh dig site with, there were some shoe marks around it they were concerned about maybe photographing.
Did you ultimately take some casts and impressions of some shoes?
Yes, ma'am.
Did you learn that there was a second site that may in fact have been another decomposed cow?
Correct.
Did you focus your attention then on burn pits?
I did do a burn pit too.
And were those burn pits located around and outside of this tree line?
Burn pit was like right up in this corner here. So it was outside the tree line, kind of, outside the fence line, but into the tree line a little bit.
All right, I'm going to show you some of the other photographs that were the aerial photographs taken. You let me know if any of those help you with your testimony regarding the burn pit. Stacy, Exhibit 190C. What are we looking at here?
I can probably just pull it out better. This would have been the main line coming in from Bonita Springs. The residence would have been here, and back in this corner, this burn pit was right in the street here.
So top left-hand side of the photograph, just on the outside of the tree line, would have been the burn pit that became the focus of your attention?
Sort of the southwest.
Okay. Now let's talk about that burn pit. When you say a burn pit, you can have a seat if you want. What gave you the indication that something had been burned there?
There was a lot of burnt trash, and it's actually still warm. So the burn pit when we got there.
We'll get to it in a little bit, but did you take temperature readings?
Yes, I did.
All right, so describe the area that we're talking about when you're saying that it's a burn pit.
It was right outside the southwest corner of the residence, and we were basically maybe looking for some items of clothing or projectiles or casings in the actual area where they were burning trash.
Did you use metal detectors?
Couldn't use it inside the actual pit. We could use it around the burn pit, but it was too hot for the metal detector.
Outside of the burn pit, did you locate anything with a metal detector that was of relevance to your investigation?
No.
Now, can't use the metal detector in the burn pit, but did you sift through the contents of that burn pit?
Yes, we did.
How did you all do that?
Well, you just shovel the pieces out and try to locate whatever you can that's not burned or too hot.
What did you find?
There wasn't one particular item. If it's the hottest part of the burn pit, where there's some grayish blue clothing that we collected out of the pit.
Was Detective Greg Thomas working with you?
Yes, yes, ma'am.
Was he essentially the law enforcement officer that was with you conducting your investigation?
Yes, he's the one that pointed it out to me.
Do you document that item,
Photograph,
photograph it, and then do you ultimately collect it?
evidence, marker it, and collect it.
When you're doing all of this, is Detective Thomas with you?
Yes, ma'am.
Do you have other items of evidence that become relevant to you from that burn pit?
No.
Do you have other work that you're doing on that burn pit?
Just the temperature settings. We're trying to figure out what the hot areas of the burn pit was. In case
Okay, so walk
you
me
wanted to
through
collect
that.
things.
Walk me through how you guys are doing your temperature readings, what you're finding.
We photographed it, and then I have a infrared scanner that you use to point at the temperature, and you get a reading. And what we did is we marked off areas inside the pit and put markers down by areas that appear to be evidence of, or items burnt. And then we put markers by all those, scanned them and got a temperature, and then collected anything we found, which was the clothing.
Did you document the temperature readouts at each of those evidence markers?
Yes, we did.
Now, fair to say that those evidence markers are still within what I'll call the circle of that burn pit.
They're inside the circle, yes, ma'am.
So if we're looking and calling it almost like a clock, they're at different numbers or points on that burn pit.
Yes.
Okay. What were the temperature readouts at each of the markers within that burn pit?
I'd have to
If you need
refer
to
to my
refresh your
report.
recollection with your report, go right ahead.
I know the hottest one we got was like 124 degrees. What I had was marker number 8. I don't know if you had a picture of that. That was the where the clothing was located.
Okay.
Registered 124 degrees.
All right. And then the next marker?
Then we went to marker number 9, which registered 102.5 degrees. Marker number 10 measured 107 degrees. Marker 11, 99.5 degrees. Marker 12, 104 degrees. And marker 13, 96.5 degrees. Marker 14, 118.5 degrees. And marker 15, 122 degrees.
Now, what time were you conducting your temperature readouts on December 4th?
That was later in the afternoon, probably around 1:30.
At that point, even though you can see the temperature readouts, can you still feel the ambient heat coming from this?
Oh, yes.
Is that what indicated to you maybe to take temperature readouts?
Yes.
Were there other burn pits on the property worked by either detectives or investigators that are not you?
Not on my side of the fence, no.
On the other side, would there have been potential items that Ms. Hager would have worked?
Yes.
And then was Detective Thomas, Greg Thomas, staying with you the entire time, or was he working other areas as well?
He was with me pretty much most of the time because him and my supervisor were the lead for me.
Was he there before you were?
Yes.
And did he stay after you did?
I'm not sure.
Okay. May I have a moment, Your Honor?
Yes.
I'll pass the witness.
Yes, Your Honor.
I'm going to grab this.
Good afternoon.
You indicated that there were several scenes that you attended and investigated, correct?
Correct.
I want to move specifically to the property, this last scene that you were just testifying to.
The search warrant?
Yes.
Okay.
I believe it was December 4th
Correct.
of 2010, correct?
2010.
So you were briefed prior to going to that property to look for specific items.
Yes, ma'am.
And what were those items?
Mainly they were concerned, they had already mentioned looking for possible spent projectiles, casings, ammunition, and I think it already came out because they were out there earlier than me about the burn pits and possible dig sites.
So you were directed, as you mentioned, to the burn pits, the dig sites, and
Correct.
I believe you mentioned that in the dig sites there were buried animals. I think it was a cow
We did.
carcass.
Yes, ma'am.
not unusual for animals to be buried outside in these types of properties.
No, I believe the homeowner's the one that pointed that out to us.
Rural area where there's farm animals, correct?
Yes, ma'am.
And you used a metal detector to search the specific areas you were directed to.
All of the dig sites and initially around the burn pit.
You did not find anything.
No, nothing metallic anyway. We did find some objects. I won't say nothing was found. As you're sifting with a metal detector, it'll alert you with a sound that there's something under there, and you'll dig that up, and it'll turn out to be a bottle cap or a can or something.
Right,
like
so
that.
nothing of evidentiary value,
Not
nothing
for
as
this.
it relates to the projectiles, cartridges, or firearms that
Correct.
you were potentially looking for.
Correct.
And there was other law enforcement officers present. I know you said there was another crime scene investigator on the other side of the property.
Yes, ma'am.
Are you aware whether they conducted a grid search?
I know there was quite a few people over there. I really couldn't tell you because I didn't witness an actual grid search.
That's okay. And again, to the burn pits. Rural areas such as this one, it's not unusual to use burn pits to burn trash.
Correct.
And I know you mentioned there was a grayish blue clothing that you located.
Yes, ma'am.
Was it clothing or was it fabric?
Fabric.
You can't say what it was.
I couldn't tell if it was a shirt or a jacket or.
It wasn't something that you picked out as evidence. It was just to do the temperature reading that you previously testified to.
We could actually see it in the burn pit, and that's why we did the evidence marker and the temperature.
But again, its purpose was for the temperature reading, and you cannot say what type of item it was.
No.
I may have one moment. Another question.
No redirects. Can they be released by the state?
Released, subject to recall or released by the defense? Recall. All right. You may step down. No need to remain outside today, but you are subject to recall. It will call you.
Yes, sir.
All right. You are welcome. Ladies and gentlemen of the jury, it is 4:56, so I'm going to send you home for the day. I'm going to remind you that you are not to do any research related to this case. You are to not discuss this case amongst yourselves or with anyone else, and you are to avoid any reports of this case outside of the courtroom. I will let you know that we are going to start back at 9 a.m. tomorrow, so if you can follow the instructions from the bailiffs, I believe they're telling you to get here at least 15 minutes or so before. They'll meet you out in the lobby, and they'll bring you around to the jury room. Please have a safe trip home. Please have a nice evening, and we will see you in the morning. All rise for the jury. The bailiff will collect them and return them to you in the morning. Be seated, and the door is now closed. Well, that was almost pretty much perfect. We got done before 5 o'clock, so that worked well. I think you deserve some credit for that. I just wanted to ask something, and then I'll see if either side has anything before we break for the evening. But on the exhibit numbering, it's a little different than normal. It appears that they are not composite exhibits. They're done separately, like 190A, 190B, 190C. Is there a reason that they're not like 190 A, B, C, and D?
Judge, I have to defer to Mr. Pruner did the numbering, and we used the same numbering for last year from the last trial, so I'm not exactly sure why they are numbered the way they are.
Yeah, but I didn't know something different, or it's a little unusual that they're separate. I don't think it's necessarily an issue, but on the list, referring back to 190, I don't have an E and F on the list.
Judge, there wasn't, and I don't know if we were using the same list from the last time, and I think that there were exhibits added as we went on that were not on the original list. So I'll have to go back and maybe edit it and send it again.
I think the record is fine. I don't see any issue with that. And They were shown to the defense. The defense didn't have any objections, so I don't foresee any problem with that. I was just a little confused with the way they weren't composite exhibits, and so they are actually tagged individually. It's 190A and then a 190B.
Yes, Judge.
Okay. I don't know. Defense.